Horizon. Here, Court of Appeals statement, the Honorable Michael J. Reardon, the Honorable Philip E. Ariani, the presiding Honorable Daniel F. Collecton. All persons have business here and draw near, business shall be heard. The United States, the Commissioner of the Court, considered.
Hello, everyone. Good morning, and welcome to the Court of Appeals. This is the second day of our case call for Panel 4 of the Court's May 2026 session. My name is Dan Korotkin. I'm joined here today by Judges Michael Reardon and Phil Mariani. And we're happy that you've joined us. Couple of remarks before we get started. First, we understand that these cases are very important to you, to the litigants, to counsel, and I want to assure you that they're very important to us as well. We have been diligently working on all of these matters. We've had the benefit of your briefing, the work of our research division here at the Court of Appeals, and our own chamber staff. All of which is to say, we are familiar with the relevant facts and the pertinent law. And so when you're up here, we ask that you try to focus your oral argument on your most important points, why you should prevail, and what is critical for us to understand, okay? Finally, we are hearing matters, as we do all the time, involving issues like sexual assault victims, personal protection orders, and issues involving children. And because these proceedings are recorded, we're going to ask that you please use initials rather than the actual name of any victim, child, or other vulnerable adult or vulnerable individual in these cases, okay? With that, we look forward to hearing your arguments, and we will begin by calling the first item for today, which is item number 16 on our case call, docket number 374826, People versus Latron Anthony Whitfield Jr. We did have someone endorsed for oral argument, but I understand that the attorney has waived oral argument. So unless there's anyone here for item number 16, nobody? Very good. So we will have that matter submitted on the briefs. Moving on to the next item, it's item number 17, docket number 375356, People versus Michael Thomas Brooks. And we do have Mr. Strauss endorsed for oral argument on behalf of the defendant appellant, and he will be appearing remotely.
Okay, I think I'm in.
Good morning, Mr. Strauss. How are you?
Oh, pretty good. I had the fancy Zoom on the computer, but it wasn't working. But I'm on the phone here.
Okay.
Good morning, everybody. Just briefly, Your Honors, we only have the one issue. The judge exceeded the guidelines by 2 months. It did not articulate any reason for doing so. And I'm sure the court's familiar, of course, with People versus Smith, 482, Mish 292. We relied upon that, where it clearly states the court has to articulate the reasons so that you could evaluate that. In their response, the prosecutor stated that while a reviewing court may not substitute its own reasons for departure, it can reasonably infer the rationale from what the trial court articulated. But that's not, and they cite what they cite. The only mention of the word infer is in I think footnote 3 of Smith, and all they said there in that case, in Smith, the judge went out of his way and actually acknowledged that he's going outside of the guidelines, and he must look to the objective facts and articulate them. He actually stated that in the record and gave a whole laundry list. And the only inference they talked about was um, you cannot use a person's occupation to enhance a sentence. And he talked about the guy being a child caregiver, but all they inferred that was that he was referring to what he did in that capacity, not his occupation. And plus, he gave a myriad of other reasons for doing so. So,
Well, what you did was, I think it can only be characterized as pretty bad.
oh,
And
without question, yes.
I think the judge brought that out throughout the sentencing, or when he was talking about what he was going to be sentencing him to. There was a certain level of maybe disgust. I think that I sensed from the transcript. Maybe you did, but anyway, go ahead.
Right. Although I've had many cases, I'm sure this court has seen many cases where they talk about the lack of remorse, things of that nature, and what actually occurred in the case, but they don't exceed the guidelines because of that. A lot of crimes are not pretty, very neat, if you know what I'm talking about. And this may be one of them, but it's still incumbent upon the judge to articulate that. And it's not even sure. It was 2 months, which is, as I'm getting older, is not a lot of time in my life. It goes back by in a second. But when you're in prison, 2 months makes a difference, and he didn't articulate the reasons for doing that. He just mentioned his observation. Yes.
Yeah. So I mean, I agree too. Any time in prison is time in prison, and that's real. Because I guess I'm wondering whether, because this is 2 months beyond the guidelines as opposed to a larger amount, whether that sort of it doesn't eliminate the need to explain the departure, but I'm wondering whether there's sort of a proportionality analysis here where, the less the amount of the departure is, the less we're going to require there to be a long and articulate explanation, as opposed to maybe a shorter explanation, or an explanation that we can infer from all of the circumstances.
Yeah, Your Honor, I respectfully would disagree with that analysis, because I don't think we can have a sliding scale, and then it puts too much weight on this court. This is one situation, but the law is the law. They have to articulate that. It's hard to say if somebody's severely ill. 2 months might mean a lot if he's going to die in prison. Who knows? There's a myriad of different factors that might go into that, but the law is the law. And on our side of it, in defense counsel, a lot of times, the judge has discretion to let certain evidence in, and whatever the law says with discretion, there's a wide range what they can do. But in this instance, the court spelled out they have to articulate it. And in Smith, that's precisely what that judge did. He articulated all the reasons, although it was a lot more time involved. But I don't think time could ever make a difference in application of the law. I don't believe so.
I interrupted you, so if you wanted to.
No, I think that's really it, Your Honor. I think the judge has that trial judge has that obligation, and then not to say anything, not to show any awareness whatsoever about the standards of the law he must follow, as the judge did in Smith. Then that puts that burden upon the court, which is totally improper. And even if it's easy in this case, to look at the facts, again, that's not the function of this court. I think it's the function of the trial court to lay out those facts and the reasons why he's doing what he's doing. He didn't do so here, because the things he said about this client, I have many cases that are on this level or worse, and there's no enhancement of the sentence.
Anything else? Okay. Anything else from you, Mr. Strauss?
No, I don't believe so. There was some kind of error with the MDOC sent a letter, but I think that's best dealt with after the court issues its opinion and the jurisdiction's back in the trial court, and we could deal with that. It had to do with the assessment of felony firearm. I think across 3 cases, he didn't articulate which case it referred to. It's just, I think he said it goes to 3 cases, 3 of the counts, something of that nature, but. I think it's going to be best that we deal with that after the court issues its opinion.
Okay. All right. Have a good day.
Thank you very much. And that case will be submitted. And
Okay, thank you.
Move on to the next item. Thank you. Have a good morning.
Have a good day. Yes.
Hey, moving on to item number 18, docket number 366322, People versus Kevin, either LaCroix or Lacroix. Maybe someone here can tell me the pronunciation, but
Perhaps as lawyers.
Well, good morning, Your Honors. Michael
morning.
Crone. I believe it's LaCroix.
Okay.
That's how I pronounced it.
It's like the water, huh?
Exactly. Yeah. Apparently, I thought opposing counsel was endorsed. I was going to keep my remarks brief.
okay.
Regardless, I'll try to get, Mr. LaCroix did file a standard for a brief. I know the court's aware of that. I know the court will decide it in, due course, but I'll just note that. Issue one, Mr. LaCroix feels, I think he'd want me to convey that he feels that's his most important issue. In fact, he re-argues it in the standard for a brief. He and I, I'll be honest, respectfully disagree with that. I think the problem there is maybe the trial court should have made some additional findings. I don't think it's the most important issue here, but he may be right. I may be, maybe incorrect about that. Issue two, that's pretty straightforward. I think that one strangulation was being described. The prosecution feels two strangulations were being described. We've attached the relevant transcript excerpts to the brief. We just disagree. I don't know if the court ever received the carport video. The court staff asked me to provide that by the time that was in May of 2025. By then, the link I had to it had expired. I didn't know if I would have known the link was going to expire. Maybe we would have saved it some other way. The same thing happened at trial counsel. You got the email. Both parties have attached it to our briefs. The prosecution, I did see an email from them saying they lost the link. I will say this, the count 4, the string, all of that, whatever happened regarding strangulation, really all 3 counts of assault, but particular count 4, were said to have happened inside the home. So they wouldn't have been, there's nothing in the video that would have shed any light on that. I hope the court has it. I don't know how that.
Well, counsel,
resolved.
how would we have it?
Only if counsel, myself, or the prosecution provided it.
And I know our court asked for
Right.
it twice
Right.
and we didn't receive it.
Right.
So I don't think it's in the record before us as far as I know.
Right. So, I mean, I don't know the answer. Now I know the answer. I didn't know the answer.
But that was presented at trial, however, right?
It was.
Right.
Sure.
So that is trial evidence
Sure,
that the
certainly.
jury saw that we do not have an opportunity to see for purposes of review.
True. But I will say if the transcript makes it very clear that the alleged strangulations occurred inside the home, would have occurred inside the home. So, I mean, I've seen the carport video. No one's ever claimed to happen. It wouldn't have helped. It wouldn't have shed any light on issue 2. That's all I'm indicating. I'm disappointed to hear that. I think the court should have been given the video, but and I would have, if I had it, I would have provided it. And I see the prosecution, their email indicated they lost it as well. So apparently it's lost to time.
It's hard for us to assess prejudice in terms of the likely outcome on the verdict if we don't have all the evidence that
Right.
the jury saw.
Fair enough, and I did have it at one time. Like I said, I didn't know it was going to expire. So it is the way it is. The court's left with a transcript. And yes, to the extent that, I don't think they do, but to the extent the prosecutor pointed to the video in support of count 4, the jury was allowed to consider it. Count 3, I think, is the main issue for the defense. Our position is it's not appropriate for an attorney in closing argument to, as a means of explaining why the complainant is having memory problems, to refer to her own trauma. She has made herself a witness at that point who is not under oath, wasn't cross-examined. I don't think it's appropriate. And it wasn't justified, necessary, or required because the complainant explained her memory problems. This wasn't really emphasized as much in my brief as maybe it should have been. She stated she was intoxicated. Both were drinking. My client was drinking as well. I'm not putting her down, but she said she was intoxicated. Therefore, she doesn't remember. So for the prosecution to stand up and say, well, it's actually due to trauma, that's a real problem. I will say this. I think it was prosecutorial error. I'm not alleging. I think it's clear in the brief. There was misconduct. Not alleging it was a crime or fraud or ethical violation, but it was wrong. I don't think it should have happened. regarding the decision to not make a contemporaneous objection. In the brief, I make the argument that trial counsel had a good, sound strategy for waiting for the jury to leave before he moved for a mistrial. And then in the alternative, I argue that if the court disagrees with me, that would be ineffective assistance of counsel. I don't think it is. I think he had a legitimate strategic reason for not objecting in the presence of the jury. In fact, the trial judge stated at trial that trial counsel was in a, quote, difficult place. The prosecution agrees in the brief that trial counsel had a sound strategy. I read that to mean sound strategy for not objecting in front of the jury, but argues that it was sexist. I'm not going to get into that. I don't understand that. I don't understand the argument. I believe trial counsel argument was not sexist. I think it made sense. It was reasonable. It's explained in the brief. I don't really, I kind of wish I don't understand what they mean when they argue it was sexist. I just haven't read that before in 30 some years.
We still have to decide prejudice, right?
True.
Even if,
True.
Even if it was
Absolutely.
wrong to make that argument to the jury. And I think that's,
Absolutely.
to me, that might be the bigger challenge here.
Well, I don't necessarily disagree with that. I'll just state on that, that's really leads to issue 4. I felt the medical records would have been important. She did describe some serious injury. There were photographs of some injuries. I don't want to leave the impression I'm arguing there was no evidence of an injury. It is what it is. His story, it's easy to, dismiss. And so, but it was a jury question. And I'll leave it at that. It was for the jury to evaluate that. And the remarks of the prosecution may be unfairly prejudiced the jury as they evaluated the evidence. We may have looked at it and said he's guilty, but it's not our decision. It's not the court's decision. Wasn't the trial court's decision. It was for the jury. Issue 4, I think, is resolved. The trial judge, he looked at the records. That's where it was left off. He's adamant. There's nothing in those redacted records that would have helped the defense. I don't have anything that I can point to say the trial judge is, wrong, misrepresenting. I don't have anything like that. We asked for an in-camera review, and that's what occurred. That brings us last to issue 5. I would say along with issue 3, this is our best issue. I mean, I honestly think issue 5 is worthy of some real consideration. Mr. LaCroix wanted to represent himself at sentencing.
Did he make clear that he wanted to represent himself or that he just wanted to not have his counsel that he currently has?
Yeah, there is some ambiguity there, but I think he was indicating, I think he indicated both. He wanted to terminate trial counsel and he wanted to represent himself. That's how I read, what he's saying. And what he said was not very articulate. I'm not excusing his behavior at sentencing at all. I mean, it was inappropriate. He should not have behaved that way. I hope I conceded that in the brief. I think if he was here, he would have to agree that was not appropriate behavior. The trial judge, you're actually not challenging the trial judge's decision to remove him from the courtroom. That's not part of this appeal. I mean, you can't behave that way in court. I would concede that. But what started it was his desire to terminate trial counsel, and I think he's asking to represent himself. Clearly, that's our position. We argue for it in the brief and so forth. If you look at, I found it interesting, the prosecution's footnote 17 at page 7, to me it indicates that Mr. LaCroix had good cause for wanting to terminate trial counsel. It's an unusual appeal where the prosecutor is harsher or more critical of trial counsel than I've been. I don't know trial counsel. If I had really strong basis for alleging ineffective assistance and making a stronger argument in that regard, I would have. Actually, if you look at footnote 17 at page 7, they are more critical toward trial counsel than I've been. And I think really it indicates to me LaCroix had reason to want to terminate trial counsel. But regardless of that, he had a constitutional right to represent himself. And the way I read the record, I don't know if the court agrees or not, but is that the trial judge ignored that right because he didn't want to deal with Mr. LaCroix's improper motions. And I have some sympathy for the trial judge because Mr. LaCroix was, filed a lot of improper motions. He was not an easy litigant, to deal with, for any court to deal with. I have some sympathy for the trial judge. I just think that the trial court, under the circumstances, should have allowed Mr. LaCroix to represent himself, have his say, and the constitutional right trumps the what was occurring from Mr. LaCroix trumps his bad behavior, essentially. He could have been sent to his cell and made his elocution and statements and been present from the cell, but still representing himself from the jail cell. That's all I have unless the court has any questions. Okay. Questions?
No, nothing for me.
Okay, thanks very much.
Thank you.
Ma'am, we already called the case. I don't know, Mr. Ferrone, do you have any objection okay, so if you'd like to.
Thank you, Your Honor. Gabrielle Ragland on behalf of the people.
Morning.
I apologize sincerely for my tardiness. Unless the panel has any questions, I can rely on my brief, but I'm perfectly happy to answer any of them.
Thank you. Any questions?
Okay, easy enough. Thank you.
Thanks for being here.
Yeah.
I'm so sorry. Thank you.
It's all right. It was a rough drive from Ann Arbor, I would bet.
All right. Thank you very much. This case will be submitted and we appreciate your arguments. The next case is item number 19, docket number 370747, in Ray Wallace Estate. Morning. Morning.
May it please the court, I am Michael Behan. I'm appearing on behalf of the defendant appellant Tracy Wallace. I'll be brief because I heard the court's instruction and I am confident in your ability to read our briefs. And I think that the parties articulated their relative positions in the briefs. And so I don't have much to add. I'll just emphasize, I think, a couple of points that I believe to be at the forefront of this. And they're two certainly distinct but related errors that we believe were committed by the trial court. The first one is the trial court's violation of this court's specific mandate to reinstate, but when the court reinstated the tax obligation on mandate, this court had expressly reversed and vacated that portion of the original judgment.
What does vacate mean?
It's over. I mean, I think that
It's a clean slate. Go back and do what you will. Trial court, is that what it means?
I don't believe so. I think that
It's not a reversal. It's not what we said. We didn't say the trial court did anything wrong. It was a vacate.
but I think that the basis on the vacate was that they had done something wrong, that they had.
Not necessarily. They go back and revisit the issue. That's all.
I don't believe that's what the Court of Appeals panel had in mind, but
Who knows? We could have asked them, but we can't. The
Sure.
order speaks for itself. The
Yes.
opinion speaks for itself.
Yeah, I think that the case law with respect to that is, we didn't have another trial. He just took the statements that were made relative to what was alleged to be a tax obligation. There was a trial. They could have done all of this prior to having had the original trial that the Court of Appeals said reversed, enter a judgment consistent with this opinion. And then the court went certainly beyond that by rendering a judgment that went well beyond what that Court of Appeals opinion had.
So if the prior panel had said expressly, we vacate, remand, for further proceedings on this issue, would you have would there be any problem? You may disagree with it, but would there be any problem with them doing that in the trial court then proceeding to have the hearing, accept additional evidence and what have you? Is there any other legal impediment beyond just sort of what the prior panel said in terms of its remand instruction?
Well, I think that if the prior panel had done that, I think that it would have opened up perhaps some argument that could be made that which the plaintiff could have brought in the trial, that there could be a refiling of, I suppose there could have been another trial on that issue. There wasn't. We had a trial. We lost. We went on appeal with respect to multiple different issues. And we prevailed on that issue, where the court did look at the Court of Appeals. The prior panel looked and said, listen, this is purely speculative. These are all based on tax returns that could have been, and the plaintiff contends should have been filed prior to the bringing of that case. There was no reason that couldn't have been done and shouldn't have occurred. So with respect, I think if the Court of Appeals had said that, that would have made this argument more complicated for us, but the Court of Appeals didn't do that. The prior panel said, we vacate that and you're done relative to, and that's where I think that issue is pretty straightforward relative to that. And as I said, there was a trial. This wasn't just an appeal on a probate accounting. We have another matter relative to that that I think will be impacted. The second issue is also something I would like to certainly highlight, and that is, there is a uniqueness, I think, to this matter from the standpoint of Tracy Wallace was the personal representative. She was removed as the personal representative. The successor personal representative filed this case. Again, we tried the case. We lost. There was the surcharge, significant amounts that has caused her to file bankruptcy. She's the residual beneficiary of the estate, which is I think cyclical in reasoning, I suppose, but the reality of it is to add interest. I think there's two issues there with respect to interest on top of where ultimately what the court had said was it's the penalty and interest that the IRS is alleging. And then to add statutory interest on top of that, I think is flawed. But I think, and I think that if I may make an argument for perhaps the court considering a published opinion on this issue, is there's not a lot of case law that I ran across relative to the distinction between when there is a judgment amount on the question of surcharge, which is clearly what the trial court found is that she's to be surcharged. And that is a different issue than compensatory damages, where sure, compensation goes back to the date of filing and there's the statutory interest and the purpose behind that. In this particular circumstance, there is the penalty that is the surcharge, but then to go back and add interest upon that is not consistent with the whole purpose in the probate code of having a surcharge. I think there is the added impact of it that she is the residual beneficiary. An issue on the accounting that we have brought, and there is another appeal that has been filed relative to the approval by the probate court of all of the accountings, is that ultimately she's, if you again recognize she's the residual beneficiary, she's essentially being ordered to pay interest, to which ultimately would and should inure to her benefit. But that's an issue that again I argued in our brief. I just would respectfully submit there's not a lot of illustrative or instructive case law on that issue, and so I framed the issue for the court, made the argument, reference the cases in which that is addressed, but I would respectfully say there's not a lot of cases on that issue, and I think it would be something that would be helpful, because these are areas, as somebody who does a lot of probate work and have done so and taught in this area, it's a little bit the Wild West sometimes when it comes to what comes out of the probate courts when there is dispute. And I think that it would be helpful to have some cases that the courts could rely upon, because there's just a whole lot of difference in how the trial courts are handling those. Thank you very much.
Well, we're here to help.
Well, I appreciate that. And interestingly enough, on this issue, the counsel for the successor person representative, the first appeal, made the request for a published opinion, which we supported, because there's a lot of cases that are cited in the trial courts. And what happens, for what it's worth, and thank you for listening to me on this, for what it's worth is that these are some certains, and people don't have a lot of money that they want to devote to having these issues fleshed out on appeal. And there's just a lot of decisions that I think are a little misconstrued by the probate courts, to which a few more published opinions in these areas could be real helpful. So I litigated the issue of in re Stillwell, which is cited repeatedly by trial courts in the probate. And honestly, I think, my humble opinion, having been the person to litigate, I think the courts cite that inaccurately about 50% of the time. And I just wish that there would be another couple of appeals cases out of the probate court that would add some guidance on it. So I appreciate the court's time, and I'll yield to counsel. Thank you.
Morning.
Good morning, Claire Winslow Gilmet on behalf of Byron P. Gallagher Jr., successor personal representative of the estate of Daniel Wallace. Before I address Mr. Behan's argument, I wanted to go over what has happened just briefly since we were here on this matter the last time. We received a 2022 opinion, and this number that we're talking about today is greatly impacted in each aspect. Mr. Behan touched on them. We're in the bankruptcy court arguing over this surcharge number. We're in the probate court arguing over accountings on this surcharge number. That's why this is so significant for us to be here today and finally get an answer on where we're going from here on forward. Now, to address Mr. Behan's argument on the violation of mandate, we had a remand back that the estimated tax penalties and interest was too speculative. There wasn't enough evidence to go through and say, this is exactly what is owed to the estate based off of these tax penalties and interest. After getting that remand, getting the numbers, the hard numbers from the IRS, from the state of Michigan, the estate went back to the probate court, said, here we have the numbers. We're no longer speculating anymore. That's not going through and arguing something that's already been decided. The vacation argument, I respectfully disagree with Mr. Behan. The idea of the tax penalties and interest, the entire concept was not vacated. It was the number, because it was too speculative. Now we're not speculating. We're not estimating those numbers anymore.
That seems right to me. I guess the confusion lies in, frankly, the fact that there was a sentence at the beginning of the opinion which is different from the sentence at the end of the opinion. The sentence at the beginning of the opinion says, we affirm in part, vacate in part, and remand for further proceedings consistent with this opinion. Okay. That seems consistent with what you're talking about. In the conclusion to the opinion, it says, affirmed in part and vacated in part, we remand for entry of a judgment consistent with this opinion. So I don't know whether, I guess the question is, when there's a remand for entry of a judgment, does that mean additional things can happen before that judgment gets entered, which I think is what happened here? There was recalculation and then a judgment, as opposed to simply the immediate entry of a judgment. Does that, you understand the question?
Yes, I do. Just out of correction, not so much was there a recalculation. We got the numbers.
Yeah, so there was new evidence presented to the court.
Yes.
More proofs, so to speak. And then a judgment was entered. And I'm just, I'm trying to piece together whether that's within the scope of the remand.
We believe that that's within the scope of the remand because the estate's position is that the purpose of the remand was to correct this guessing. And to return back to the probate court with a lack of guessing solves the issue that the Court of Appeals originally had with the number that was presented. On our next point with the statutory judgment interest.
Hey, counsel, before you move on, I gather, and maybe I'm incorrect, but opposing counsel's argument seems to have a suggestion underlying it that everything you offered on remand was functionally things that reasonably could have been offered at trial. And I guess can you speak to that? Because obviously sometimes you go to trial and the proofs come in a way that leaves things speculative and you don't always, get a chance to then, supplement the record. Right. So I guess tell me a bit more about why that's not the case here, or why that isn't the right way to think about it.
The way that previously these numbers were presented was based off of a forensic accounting by an expert CPA, put together to estimate based off of the lack of payment of these taxes and what the penalties are estimated to cost, what the interest is estimated to bring in over the course of around 8 years of not paying the taxes. That was an estimated number because the IRS in the state of Michigan had not issued that penalty yet. We were still putting together, fixing the accounting that got us into the surcharge order, the removal of the original personal
So
representative.
at the time of trial, those numbers,
They didn't
those
exist.
final numbers were not available at that time.
Exactly. So they needed to be estimated to have some level of number to be able to say, this is what we're asking for. They were too speculative in the court's eyes. Once we got the true assessed numbers from both the IRS and the state of Michigan, there was no more guessing anymore, and there was no more speculation. That is the estate's point of view on that following of the remand. As to that statutory judgment interest, the number that we're talking about is a three-prong issue. It's the surcharge, and for conciseness, $398,000. Then we're looking at this IRS alone. The IRS has their own statute. The IRS has their own tax penalties and interest number. The state of Michigan has its own tax penalties and interest number. When all of those are added together and they come down to that final number that we're asking for, the estate's position, that is damages. The estate was damaged in that amount based on the breach of fiduciary duty from the first personal representative. That is where the statutory prejudgment interest dating back to the date of complaint, because the estate was injured from then. I understand counsel's point of view on this interest on interest, but it's accruing anyways. It's already here and it's hurting the estate because we're still not resolving this issue on the number. We're still dealing with this. So the statutory interest goes to make right when a plaintiff is damaged through the beginning of the complaint on to the end. And that's what we're asking for here. We're not asking to make an example or to go through and extra surcharge whatever we can get. We're trying to make whole the estate's damages. And I'd be happy to take any questions on that matter.
Nothing further from me.
Thank you.
very much. Any rebuttal?
I do not. I think the issues are before the court. We've done our best, I think, both sides of laying them out for you, and look forward to getting your opinion. I will echo the one thing that council mentioned. This does have bearing on a lot. There's other matters that are waiting. We have the accountings that the trial court approved based on all of the numbers of which we filed the timely appeal. There is a bankruptcy court to which the stay was lifted for purposes of this argument, and I was permitted by the bankruptcy court to come and make the argument because I had to get approval relative to that. But we anticipate and look forward to this court's opinion. Thank you very much for your interest in the case. So. Thank you.
Thank you
Thank
both.
you. Have a good day.
Okay, that matter will be submitted. Thank you very much. The next item we have is item number 20, docket number 374739, AC versus Auburn Copeland.
Good morning, Your Honors. Mark Linton appearing on behalf of the appellant, Etoy Poplar, as next friend of AC, a minor. Your Honors, our first argument is the trial court misapplied MRE 410 by expanding it beyond its text and purpose. MRE 410 provides in a relevant part that evidence of a no contest plea is not admissible against a defendant who made the plea. However, the rule is limited and it does not exclude independent evidence, nor does it raise the factual existence of an investigation or subsequent government action. Here, the trial court expressly ruled, I am precluding any evidence having to do with a no contest plea, a conviction, presence on the sexual offender registry, and successful prosecution, no charges filed. That ruling went far beyond MRE 410 and excluded evidence of a police investigation, the involvement of Child Protective Services, and the referral to the prosecutor.
Okay. If I remember right from the transcript, it does seem that evidence of the fact of an investigation, both by DHHS and by the police, was allowed in. It seemed like the place that the court, put the stop was, referring to the prosecutor and the charges and the plea and everything that adhered in sort of the plea that was entered. Is that correct?
Well, yes. And so in the same proceeding, the court actually recognized that such evidence could be admissible, and it ruled the fact that she spoke to a police officer or a DHHS worker that there was an investigation that can come in.
And it did.
But the problem is it seems to be internally inconsistent in that ruling. You're in one respect saying that you're excluding all of this evidence, and then you're making a prior inconsistent ruling that you're going to allow some of the evidence. So if you're trying to prepare because the initial ruling was based on a motion in limine, at that point, you believe you're extremely limited as to what you can present in the way of evidence for your case. So I think.
Well, it looks like the plaintiff's motion in limine asked for the admission of some, specific items, right? And as I understand the brief on appeal, there's 3 of those that are being challenged. It's the conviction, the SORA registration, and the termination of parental rights. And from the motion in limine, it looked like they were trying to submit a document that evidenced SORA registration, which happened as a result of the conviction, the judgment of sentence reflecting the conviction, and the order of termination. That's how that's what appears to be on the face of the motion in limine that was offered to the court for these are the evidentiary proofs we want to offer. Is that correct?
Yes, Your Honor.
And I know those things weren't allowed, and it also seems like in the motion in limine they were all offered. Their relevance was offered or is explained in the motion in limine as to prove that he did these things. Right? That's why these things were offered, was to prove that he committed the alleged abuse that was at issue in the case.
Your Honor, it's our position that they were offered as a context to the situation to show corroboration. The reason it's important is because when this is really coming down to a credibility driven case, the excluded evidence is critical because if allowed to present it provides a context, and it's showing that the government did take action. There was enough credibility here that allowed the government to move forward in multiple respects here. So I think that by excluding this, you're weighting it so heavily in favor of the defendant because of this no contest plea that it takes out the whole context and the situation, as well as the possibility that the jury could weigh the credibility of this evidence and the kind of showing that these acts actually occurred.
What's the point of entering a no contest plea if that can then be used in the subsequent civil action? Isn't
Well-
that, I mean, that's, I thought one of the main purposes of the no contest option.
Well, I would present that the no contest plea is basically allowing the defendant to not have to put a factual basis on the record. And instead, they can rely on either a warrant or a police report or whatever document is going to be used for that. And so that would prevent, that factual basis and the fact that the defendant entered a no contest plea, which is treated as a guilty plea, to be presented to the jury. But I don't think it's expanding beyond everything else regarding the context of what happened, the investigation that occurred. And so I think that it would be narrowly limited to just that basis.
You're saying you were prevented from introducing evidence that there was an investigation? I guess I'm consistent with Judge Mariani. I was under the impression that that evidence was allowed. What was not allowed was the direct evidence of a conviction.
Well, I think
And a SORA registration.
and it also the fact that that no charges were filed is what the judge ruled, and successful prosecution. Again, I would argue that it's a limited situation to not prejudicing a defendant by having whatever the factual basis is read to a jury from a police report or whatever, it is. And the fact that that is a guilty plea based on no contest, I think it's a narrow, limited scope to that part of the process. But I think the judge went beyond that and basically limiting anything to do with prosecution of the case. So, that would be our position. That really highlights my main argument. So I don't know if you have any other questions or.
No, I don't think anything further from me.
Thank you very much.
Thank
you. You'll have time for rebuttal.
Morning,
Morning.
Michael Edmonds, David for the defendant appellee. I'm not sure whether to respond to the appeal or to the oral argument, because this is a different argument that I responded to in my appeal brief. The appeal seemed pretty clear to me. The judge should not have excluded the no contest plea, should not have excluded evidence that my client had to register as a sex offender, and should not have excluded evidence that he lost his parental rights. And so that's what I briefed, and that was what I was prepared to respond to. So I will address that briefly, because I think you need to hear my response, but then I probably need to respond to what I just heard. So of those three arguments, I think the first one is the most important to me, because I think the other two are going to be determined by your decision on the first issue. And I'm not going to spend a lot of time on the language of MRE 410, because it says right in there that a no contest plea is inadmissible, with exceptions that don't apply here. Despite the argument in the appeal that the only thing that 410 excludes is statements made during a plea. That's not what the court rule says. You've got the court rule. I want to respond to the relevance argument, because the second argument from the plaintiff was, even if 410 would otherwise exclude this, it should have been admitted because it's relevant. And I briefed the issue, but as I thought a lot about it, I thought about a different way of approaching it. So here's what I want to be able to explain. The starting point of 401 is generally relevant evidence is admissible and irrelevant evidence is inadmissible. But then the rest of the court rules that start with a 4 are all exceptions to that. So the fact that something's admissible, something's irrelevant, it's not admissible. But if something's relevant, that doesn't always make it admissible. So you got 410, you've got 408, offers to compromise are relevant, but they're inadmissible anyway. You've got subsequent remedial measures. All of the other court rules say even if something's relevant for public policy reasons is inadmissible. And that's what 410 says. So it doesn't matter if a no contest plea is relevant. What matters is it's inadmissible pursuant to Rule 410. Once you accept that argument, the second two prongs of the plaintiff's appeal fall. If you can't tell the jury that my client pled no contest, then you can't tell him that he's a registered sex offender because you're left with two options. Either telling him that he registered as a sex offender as part of his plea, which just undermines 410, or it's left with the jury to speculate about why he's a registered sex offender. Does that mean he pled guilty? Does that mean he was convicted? Does that mean he's a sex offender for some other matter? So they go hand in hand, the first two arguments. The third one's a little bit different because the argument about parental rights isn't determined.
You know, getting in the fact that he's a registered sex offender, that might be better evidence than a no contest plea because it leaves it open to speculation for the jury.
Better evidence for the plaintiff.
Right.
Yeah, and therefore more prejudicial to me.
Exactly. More prejudicial to you.
Because the jury's then going to sit there and wonder, what did this guy do?
Yeah, what did he do? That's happened to me in trial where I've argued to keep something on. The judge let in on another gun. I thought, I was a prosecutor, and I thought, that's not too bad because now the jury's going to wonder, what did he do?
It's even better when you trick the other side into making that argument and then you're playing chess. But I can't claim that I did that in this case.
Well, I can't claim that I ever did it too. I just lucked out.
It does happen that sometimes when you lose an evidentiary issue, you're better off than if you would have won it. I agree.
Right.
But at the end of the day, I mean, this went to a jury on, there's a reference in the appeal brief to somehow excluding evidence of what he did. No evidence of what he was alleged to have done was excluded. The witnesses testified to what he did, and the jury didn't believe him. I tried this case and the jury didn't believe him. How do I try this case with all this other indicia of wrongdoing that he never pled to? He's never once admitted he did this. He pleaded believing that the court rule would protect him. It seems like such a letter of black letter, an issue of black letter law that I didn't even have to argue at the motion in limine. The judge asked a bunch of questions and said, tell me, give me a case that says you can introduce a no contest plea. And the evidence that the plaintiff came up with at that time was the exception to 410 about someone who files a lawsuit later on after pleading no contest and the defendant being allowed to defend themselves with evidence of the no contest plea. That was the case that they relied upon, clearly inadmissible and didn't go anywhere. So I don't see that anything has changed with respect to the evidence. What has changed with respect to the argument is the oral argument. And what I took from the oral argument today was that it wasn't fair.
Could we go back just, I think before, you were starting to say that the third issue, the termination of parental rights, the voluntary termination.
Thank you.
Was like a little bit different. Could you address that before you go on to
Yes,
the oral argument?
thank you for directing me. So, and I'm not an appellate lawyer, so I apologize. So, that issue is determined by 401 and 403. It's just a relevance and prejudicial, more prejudicial than probative issue. My problem with that issue is it's similar to the second one in the sense that without telling the jury why my client voluntarily relinquishes his parental rights. In fact, the fact that it was voluntary, he wasn't forced to do that, and that he voluntarily did it as part of his plea, then the jury is left to speculate. All they know is that he's lost his parental rights. They don't know why. They don't know when. They don't know whether it was because of something else.
Well, counsel, I guess when I look at the termination order, it identifies a statutory basis for the termination. That statutory basis requires a conviction. So I mean.
So if that was presented to the jury, then they would know about the no contest plea. If they were just told about it, then.
It seems like there is a connection there, a 410 connection on the face of that order.
Either way, the jury knows about the conviction, in which case it's inadmissible, or they don't know about it and they're left to speculate and wonder why does the fact that somebody's lost their parental rights mean that they molested their daughter? Those two don't go hand in hand.
If he had lost, if during the hearing at which he voluntarily terminated his parental rights, he had made an admission to the underlying conduct, we would be in a different place here. Is that
not a different outcome, but a different court rule? Then they would be excluded as statements made during plea negotiations. That would be 410 sub 4. Depending on where the plea, if the plea was in open court, then I agree with you.
Yeah.
Those would be admissible, but he never did that.
Because I think during the motion hearing on this matter, it was read into the record, the hearing and the termination matter.
Correct.
And in that hearing, your client did not admit to any underlying conduct.
Correct.
It was sort of the equivalent of it was sort of the TPR equivalent of a no contest.
That is correct. He only answered questions about whether he understood and whether he agreed to the plea and that sort of thing. He never gave a factual admission to what he was accused of doing. That's right. So where I was moving to is today we get this argument that somehow the plaintiff was prejudiced because she was not allowed to provide context to the allegations against my client. And I don't quite understand that. Plaintiff was allowed to tell the jury that there was a criminal investigation. We heard from a police officer. We heard from a social worker. We heard from a third person. I can't even remember who it was. The judge just said you can't
Isn't there
say.
also testimony regarding the sexual abuse by the child?
Yes. Yes, that was the only witness who testified to what she alleged happened to her. But the point is, the judge's limitation on these witnesses was you don't get to say we charged him with a crime. You don't get to say he pleaded no contest, and you don't get to say that you vouch for the plaintiff. You don't get to say we believed her and that's why we charged him with a crime. That's all the judge said. And that's because he didn't want to take the case away from a jury. He wanted the jury to make that decision based on their own analysis of the two principal witnesses, the minor and the father, and they did. So I disagree that plaintiff was not allowed to provide context. They are not allowed to provide context to prove the credibility of the minor based on what the police officers believe. It's just. So I haven't heard anything today that changes my arguments on appeal, and I think that the argument today was factually incorrect in the sense that the plaintiff was hamstrung at trial. The only thing plaintiff wasn't allowed to do was introduce the police officer's subjective beliefs about who was telling the truth and the fact that my client was charged and pleaded no contest. Anything else?
Nothing for me.
Thank you.
Thank you very much. Mr. Linton, any rebuttal?
I would just make, I guess, this comment. So again, this MRE 410 seems to be expanding, I guess, in the scope of what I think was originally intended by it. Now, again, if we're excluding the Sawyer registration, yes, would it leave a jury to speculate as to why they're on it? Yeah, but I don't think that that's necessarily within the scope of a no contest plea precisely. The other being the termination of parental rights. Again, I don't think that's within the scope precisely of the no contest plea. And as for relevance, I would just note that the Michigan Supreme Court has explained that all relevant evidence is inherently prejudicial. The question is whether it's unfairly prejudicial, and that's People v. Mills 450, Mich 6175, 1995. For the idea that trying to argue that it's unduly prejudicial, I don't think it rises to that level for this particular case. So I don't know if you have any other questions or. All right.
Thank you very much. Thank you both. That matter will be submitted.
Thank you.
All right, moving on to the next item. It's item number 22, docket number 375-272, Sue A. Wilkes versus Department of Treasury.
Good morning. May it please the court. James Allen Zemer appearing today on behalf of the Michigan Department of Treasury. I intend to keep my remarks brief and focused on the substantive issue here. This is a tax exemption case, and the statute contains a bright line prohibition when a person files a non-resident tax return.
This is a strict liability crime then, or excuse me, strict liability statute.
That is the way we view it, and that's the way it's Treasury interpreted.
I think you're probably right on the wording of the statute. But do you think the legislature intended that?
Yes, Your Honor. We do believe the legislature intended it, and as kind of a roadmap here, and we laid this out in the briefing, but there was a parallel prohibition with individuals that obtain a similar exemption in another state. And usually that pops up. Some states, for example, have automatic. So I believe Arizona, if you purchase property in Arizona, they automatically enroll you as a principal residence exemption, and people have to take an affirmative step to rescind it. The legislature, after this court's decision, went back, revised it and clarified, yes, it's, if you receive it, you're out. You're not entitled to the PRE for that year.
Oh, I'm sorry.
Oh, go ahead.
I think I understand that circumstance, and but I guess in terms of imputing the same rationale to this circumstance, because obviously the legislature addressed that expressly in the statute. It added language, right, to make clear sort of how, and it didn't here, but that obviously doesn't. That only tells you so much. But in terms of this, you know, if we assume, you know, it was a mistake, let's say, or it happened, what benefit would someone get from going about things the way that the plaintiff did here? You know, what would the legislature be trying to deter or fix by prohibiting the fixing of a mistake that the way that the plaintiff is trying to do here?
Can I add on to that question?
Yeah, please,
Specifically, what
absolutely.
benefit did Ms. Wilkes get from this?
She received the benefit of a tax exemption, and that's
She didn't receive any benefit out of the state of Washington, did she?
no, not out of the state of Washington, because Washington doesn't have a
Because
PRE.
it seems like if you view this as a rule that's trying to deter certain conduct, I guess I'm trying to figure out what they're trying to deter. I mean, obviously you want people to not make mistakes, but you know, is there some like gamesmanship, some, you know, double dipping, something that we're trying to say the rule needs to be this strict in this context, because otherwise people will take advantage of it and get a, you know, improper sort of benefit or improper sort of result. And I'm trying to figure out how what that might be here.
Sure, and I'll openly admit, it's not as straightforward as necessarily the corollary provision where we're talking about receiving an exact another exemption in another state. The gamesmanship here is double dipping. One, they're receiving the benefit up front while they're claiming to not be a resident and not subject to income tax in Michigan. And simultaneously, they're claiming an exemption in Michigan and receiving that property tax exemption. So,
But did they get anything out of that aside from just, I mean, aside from potentially imperiling their claimed benefit later? I mean,
potentially, Your Honor, but just playing this out. So if that income is attributable to Michigan, then all that income would be taxed and taxable in Michigan. So by declaring that they're not a resident of Michigan, all that income is no longer subject to tax in Michigan. So,
But once she files the amended tax return, it is, right?
so if she's declaring that that income is now taxable in Michigan, yes. This is complicated, and this fact pattern, it's complicated because she filed married filing jointly, and her husband was the primary breadwinner, and his income tax was still attributable to the state of Washington. But there's a number of different ways this could arise, where the tax is, you have a single filer and the tax is attributable to another state. So the gamesmanship here is getting tax treatment for income tax one way and having residency and property taxes treated separately. That's the gamesmanship, and trying to create uniformity. The other part,
I'm sorry, maybe I'm misunderstanding. Once she filed the amended tax return, isn't it, you know, with the correct box checked? Doesn't any income that she had previously not had to pay tax, wouldn't she then have to pay taxes on as a result of checking the correct box on the amended return?
correct.
Okay.
But this is also turning into a game of gotcha, where again, this occurred as a result of Treasury catching it, denying the PRE. It went to informal conference. Then the amendment happened. So the onus is now getting put on Treasury to go out and find these and issue the denial. And then we get to a trial and now they're amending. And that's part of, because we're dealing with two separate tax systems and property taxes get into the foreclosure route, and there's other consequences there because they're separate. It's a straightforward rule. It's a bright line rule. If they filed the amended return, Treasury knows what they're looking for auditing, how to administer this. And when we get to a trial, we know what we're adjudicating. There's a straightforward fact pattern. Was it filed? Was it not? We're not taking in new evidence. We're not looking at intent, whether it was a mistake. We're not getting into any of that. It's just a
So if
strict
Treasury
liability.
hadn't caught it, then the plaintiff would have been able to enjoy a beneficial treatment on the income tax side.
Correct.
That was not, that wasn't appropriate. Is that what you're saying?
Correct. And while this particular fact pattern, it wasn't that substantial, depending on how this rule is applied and how this court issues its decision, it could be substantial, depending on the fact pattern and the taxpayer. That's the primary issue we're here to address. I welcome any questions this court may have. Other than that, I'm going to reserve the rest of my time for rebuttal.
I think that's it for me.
Thank you very
Thank
much.
you.
Good morning, Your Honors. Alex Tolzman on behalf of the appellees, Mr. and Mrs. Wilkes. The Treasury's main argument this morning focuses on tax year 2021 and the amendment of the income tax return for 2021. I think the important distinction here in this case with these facts and the cases cited by the Treasury is that Ms. Wilkes did not amend her tax return to change her residency status. Mr. Wilkes did not amend the tax return to change his residency status. It was to add the residency status of Ms. Wilkes. So there's a distinction there between the amendment of the tax return to change the residency status to engage in gamemanship.
But counsel, can I just ask, just so I can
Yes.
visualize it better, for the 2021 return, I guess, what exactly needed to be amended? Was it the 1040 form? Was it the Schedule NR? Was it both? Do you know?
It was a 1040 form only, I believe, to change and add the residency status of Ms. Wilkes.
Because on the form, it has it lists residency status, check all that apply. And only non-resident checked.
Correct for
So you needed
Mr.
to add a resident check.
Correct. So the original return checked non-resident for Mr. Wilkes' residency status.
Right.
The amended return checked both statuses to include Miss Wilkes' residency status as a resident of the state of Michigan in the 2021.
And what did and presumably there was a Schedule NR filed?
I'm not sure of that.
Okay. It seems like if you have a non-resident, you would, one non-resident, it seems like that would have been required. Okay, but you're not sure if that was.
No, not off the top of my head. No,
Okay.
Your Honor.
Okay, thank you.
So I think that's the distinction here, and the other cases cited by the Treasury is not an amendment to change your status to gain some kind of benefit, whether that's the equal tax benefit of another state. You see that with the MAG versus Department of Treasury case, where the residency status was changed to get a similar benefit in the state as opposed to the other state. That's not what occurred here. We're just correcting an error that was addressed when the Wilkes learned that the error had occurred, which was at when the Treasury pointed that issue out to them. It was promptly amended to include her residency status. If you look at the,
I'm sorry, what about counsel's point about, if the mistake had gone uncaught, then it would have yielded sort of an improper, income tax benefit to your client. Is that accurate? Or tell me more about that.
I think that's a separate issue than the property tax that's at issue here. So as the briefs indicated, Mr. Wilkes is the primary breadwinner. He's the one with the income. Ms. Wilkes was not at the time. So the issue here is the property tax benefit that they receive.
Yeah,
or
I
don't
think
receive.
that's probably I understand that's probably the case in this particular situation, but I think the broader question is, right, because if we issue a holding about this particular subsection of the statute, one question is, will it incentivize some sort of gamesmanship, either with respect to PRE status, which I think you're saying no, okay, or could it sort of inadvertently incentivize some sort of gamesmanship status with regard to income tax liability? Which is to say, if someone says that they are not a resident, and then they, later say they are a resident, they might have more income tax liability by saying that they are a resident. And if that's not, if that's not caught early on, you could have more people sort of checking the wrong boxes.
Yeah, I understand the distinction and the concern there with creating kind of a loophole, so to say, of like creating this tax incentive to file incorrect taxes. I think there are safety nets and procedures to address that, though, in the tax return. So when you file your tax return, you're stating under oath that this information is correct to your knowledge, information, and belief. So the amendment is to fix any sort of mistake that you've made under the penalties associated with signing that document. So I think there's already some protection to address that kind of concern at the income tax level. For the property tax, the Michigan Michigan Tax Tribunal addressed the legislative intent of what they thought the legislator's intent was with this statute, that this kind of amendment was permitted. We're not, as I said, not amending to change their tax status. It's amending to add that resident status for Mrs. Wilkes. If you look at the totality of the circumstances in this case, from 2020 to 2023, which are the original years at issue, you can see that the factual circumstances don't change. Ms. Wilkes occupied the property. She had a Michigan driver's license and a voter's registration. So you can see through the years, beginning in 2020 with the occupancy, that it was a Michigan resident status was the correct status for Mrs. Wilkes. If you look at 2020 onward to 2023, you see those factual circumstances don't change. She was here for the purpose stated in the briefs. She continued to be here in 2023 for those same purposes. She continued to have Michigan driver's license and voter's registration, and continued as normal. For the PRE exemption, no one document is dispositive for that award or denial. So if you look at everything that was submitted for all years at issue, you can see no change there. And unless there's any other questions, that's all I had this morning.
Thank you very much.
Thank you, Your Honors.
I only had 2 quick points. And to follow up, Your Honor, on your question, specifically, yes, there was another schedule that needed to be added, the Schedule NR, I believe. If they're going to list or check multiple boxes, yes, then they need to spell out in the following schedule who's a resident, who was not a resident, what was the time period. So yes, it does involve adding a schedule in the amendment.
You know what this return, do you have any?
I believe they did add the Schedule NR in the amendment. From recollection, I don't want to say definitively, but I vaguely remember seeing that. Regarding the second point, and this really drives at the heart of the matter, residency ultimately is a question of intent. So people can occupy, they can own it, but it's ultimately driving at mentally, where do they intend to have their one true fixed and permanent home? It's a factual question. When they make the statement on the return saying, I'm not a resident of Michigan, that's under penalty of perjury. That's a declaration of their intent. And we put this forth in the briefing, but understanding how residency is and where the legislature was coming from in making this bright line rule and saying what, not just for the gamesmanship, but this is a declaration under penalty of perjury declaring their residency. They can rely on that to deny the PRE. I think that's sufficient.
Just a quick question, Council, about the scope of the dispute. Right now it's the years 2020 and 2021 that are in dispute.
That's it.
And does the amended return issue affect? That was the amended return was for the tax year 2021.
Correct.
So does that issue affect 2020?
No.
Okay.
No, that doesn't affect, and we put forth our argument on 2020 and specifically it dealt with intent and we believe the trial court didn't, or excuse me, the tribunal did not make a factual finding of intent, which was required. But for 2021, that's a dispositive issue. And that's the issue here that Treasury is primarily concerned with because this is going to have broad implication. It's not necessarily going to be limited to the facts of this case. So, other than that,
Nothing more from me.
we'd ask that you reverse. Thank you for your time.
Thank you very much. Thank you both. That matter will be submitted. At this point, we're going to take a brief recess and we will be back to continue the 11 o'clock portion of the call. Thank you.
All right, please. For appeals, the state of Michigan is now in session. We did.
All right. Thank you very much for your patience. We are going to resume with the 11 o'clock portion of the call. And we're going to move right along to item number 23, docket number 374989 in Ray Mata Estate. Good morning.
Good morning, Your Honors. I'd like to reserve 5 minutes for rebuttal. if I
Okay,
may.
we'll ask you to keep your own time, but that's fine.
Okay, thank you. Elizabeth Parker, appearing on behalf of the appellant Luz Maria Metelka. The issue in this case is really very straightforward and the facts really are not in dispute. The issue is whether the offer to purchase her father's property submitted by my client should have been accepted over the multiply amended offer submitted by the Mata Farms LLC. And I believe there were 2 errors in the case that I would like to specifically address. The first, when we look back at the initial purchase agreement, which was signed by only 2 children as buyer, dated August 7, Ms. Metelka's offer was accepted as the backup to that offer. That offer identified a closing date of August 18 and included the relatively standard but important term that time is of the essence. No closing took place by that date, and instead there was an amendment that was signed December 2024. But that amendment wasn't signed by the original buyers, but rather it actually changed the identity of the buyers, and it was only signed by those buyers. And so I think just by sheer force of logic and an application of straightforward contract law, by the time of that amendment, the terms of the original PA had expired and my client's backup offer should have been accepted and the matter closed. That didn't happen, unfortunately. Instead, upon receipt of some additional correspondence from representatives of some of the other children, the PR filed a petition for instructions asking the court which of these purchase offers should be accepted. Now, at that time, the face of both of those purchase offers had changed. The original purchase offer that has been described as amended really reflected nothing in terms of what the original purchase offer agreed did. It had different parties, it had different timing on the closing, it had different financing requirements. It was just fundamentally different offer. The offer that my client submitted at that time was significantly more advantageous to the estate. It required no financing. It had a closing within a week. It didn't require any delay in time to permit her to acquire the funds. It would have paid into the estate relatively quickly. It was actually superior to her prior offer in as much as while the overall purchase price didn't change, that initial purchase offer had an offset included for her claim against the estate, her services that she had provided. Her newly submitted purchase offer did not contain that offset. So she was willing to put the money straight into the estate, deal with that issue later.
Does the number of children involved here make any difference? I think you have 6 that want to purchase the place opposed to your client, 6 out of 15, I think. And
There were 16 children total, 15 living at the time Mr. Mata died. And so that deceased child had 2 children of their own who stood in those shoes.
Okay.
No, I don't believe it does.
I appreciate the trial court's own experience, which I believe he related in the hearing. And I think that did motivate him that, well, I'm going to benefit more children versus fewer children. But I don't think at the end of the day, the benefit is to be to the estate, not to this group of children versus this group of children. There were children who were not parties to either agreement who advocated for my client's offer to be accepted. And so, to look at it in terms of just, how many people do we have on one side versus another, that really doesn't serve the interests of the estate as a whole. And so I believe at the time of the hearing, given that the offer that my client submitted was certainly superior in all respects, it should have been accepted, and the court erred in not directing that to take place.
But that could only be considered there's kind of an order of, there's like a sequence we have to go in here. Don't we first have to determine that the original contract was no longer being amended, that we were onto something completely different? Because seems to me if we think that the subsequent contracts were simply amendments of the original contract, that the question of whether your client's offer was superior doesn't really come into play. Am I thinking about that correctly? Like first we have to figure out the first question, and then we go to whether, then we compare the two offers?
I do agree with you. And I think that's why I said there are two errors. I think that first error took place in not simply saying that original agreement failed, and by its terms, my client's initial offer should have been accepted.
I just wanted to make sure we were going in the right order of how we would go through these things.
No, absolutely understood. And so I do think that was the first error. And I think that was, the error that was occasioned before the PR even submitted the petition for instructions. Getting us to that petition for instructions, however, that had sort of been, I don't want to say resolved, but somewhat mooted by the fact that there were now these entirely new offers that were being presented and being weighed on their face. I think, quite frankly, the initial error in not considering that first purchase agreement to have terminated by its terms and accepting my client's first offer, that's what should have occurred. Clearly it didn't, and we ended up some months later arguing over two different purchase orders. But I think when we even jump ahead to that point in time where we're looking at these two different purchase order offers, you could still argue that that amendment isn't really an amendment at all, because the initial purchase agreement terminated on its face, and it's no longer an amendment of something that doesn't exist. So it isn't entitled to that sort of pre-existing status to whatever extent that might matter.
And how do we determine whether the August 7th, 2024 agreement was merely being amended or extended as conditions warrant? That's the language of the original contract, or whether it had actually been terminated and we were talking about a different offer or a different agreement.
Sure.
Is that a legal question? Is it a factual question?
Well, it's a little bit of both, but I think it's pretty clear on the face. If we look at that original agreement, Mata Farms LLC was not a party to it. And so it could not execute an amendment to that agreement. It wasn't even in existence at the time of that agreement. So the parties that needed to be executing an amendment to any agreement were the original buyers, and that didn't happen. And so if we go simply back to the terms of the agreement, it provided that the failure of the buyers to obtain a mortgage results in a termination of the agreement. That's at paragraph 20.
Why is it not, I guess, why is it not an amendment for the two individuals who are the proposed buyers to seek to amend the agreement to replace them individually with the corporate form that they had created? Like, how do I know? I mean, you're saying that very categorically, but I don't remember seeing legal authority in your brief to actually expound upon that point. And it's not obvious to me.
I don't believe a non-party to a contract can amend it. I think that's fundamental.
Why is it Mata Farm making, it seems like you're saying that the corporate form is the one making the amendment. And I'm saying, well, it seems like it's the two individuals who are seeking to amend the agreement to swap in place of them as individuals, the new corporate form. So why is that wrong?
That is wrong because those two individuals never signed anything saying that. And if you look back at the terms of the amendment, the December amendment, it does not identify them at all. as being the parties amending to somehow bring into this new party. It's only Mata Farms that's signing it. And that's an entity that didn't even exist when the original contract was entered into. And so certainly there was a way to get there, but they didn't get there the right way under the law. I don't believe that we can allow a non-party to an agreement to enter into an amendment of that agreement without the original parties agreeing to that and some evidence of that in writing. And so I think, when we talk about contracts, we look at their terms, we look at the plain language, we look at what they say.
But are you suggesting there's some dispute whether those two individuals agreed to this amendment?
I'm not suggesting that. I'm suggesting that there's no documentary evidence supporting that interpretation of the contract. They may have.
So could the trial court, as a factual matter, find or conclude that the original two proposed buyers were, in effect, were amending the contract to sub in the LLC?
I do believe there could have been a factual conclusion to that. The problem I have with that, however, is that you do have another purchase agreement that is relying on those terms of the original purchase agreement being executed as they're written. And so when my client is waiting for this original purchase agreement to be either fulfilled or fail by its terms, and it doesn't happen, she has the reasonable belief that her purchase agreement comes into place. And that I believe that should have just happened just by force of the PR reading the documents and saying, this is what we agreed to. The financing failed. I need to take Ms. Metalka's purchase agreement now as superior. But where I think it does become a little convoluted and why there's sort of this second error that makes it a little more complicated is when we get to the point of the hearing, there is this Mata Farms agreement that's not really in writing yet because it hasn't been reduced to writing, that not only adds an LLC that didn't exist at the time of the original agreement, but also wants to add another individual and wants to extend to wait for financing for another, time period to allow her to obtain financing through her retirement funds. And so it was just this ongoing, well, let us try this, let us try this, let us try this. And meanwhile, there's my client saying, listen, I'll even make my first offer better. I won't require the set off of my claim against the estate. I'll just handle that separately. And I believe when the court was faced with those two competing offers, essentially to not accept my clients was an abuse of discretion. And one point that I really want to make to the court that I think is somewhat outcome determinative. The March 7 order gave Mata Farms LLC, it required it to close within 30 days. That was not done. The stay in this case was not entered until sometime in August. And so that 30-day period had expired in April. Nobody presented any evidence to the court to say, hey, we're ready to close. We've met this condition. We're ready to move on. Instead, it just languished. And again, my client is left with this offer where she's saying, I've got the money, I will pay the estate, but can't we close? And so I think that is telling of the fact that there's just still this ongoing back and forth, and there's no reason for that. And so, given what I think are two different errors, but they kind of end up in the same place, I believe that the trial court should have ordered the PR to accept one of my two clients' offers. At this point, her outstanding claim against the estate has been resolved. And so even accepting her first offer, the end result would be the same. Unless there are any further questions, I will. Thank you
Very much.
Thank you. May it please the court, Doug Chalgen on behalf of Applee. I object to the post-order representations. I don't know about any of that. I would rest on our brief except to say in agreement, this is about abuse of discretion. It's a simple abuse of discretion issue. The appellant goes to a lot of trouble to try and make the decision that the trial court faced that day seem more complicated than it was. The history of delays and contract provisions are red herrings. The contingencies were gone and the delays were over when the trial court was presented with two very similar offers. The offer from appellants would have netted the estate slightly less than the offer of the other family members because appellant's offers was reduced by a $6,000 commission. The trial court chose the bid of these other family members, but allowed them only 30 days to close, or the opportunity would shift to the appellant. This is a principled outcome. This is a reasonable outcome within the discretion of the trial judge. As we say in our brief, Solomon-like. All right, you guys, this has gone on long enough. You got 30 days. If you don't get it done, then give it to her and let her buy it. Whatever the trial court stated, and I appreciate, Judge, your question about how many kids are on one side or how many kids on the other. I agree. That probably doesn't have anything to do with it. But that doesn't change the fact that on this day, there was this, and people substitute in contracts for real estate. My gosh, I'm sure this court has sat through 1,000 real estate transactions in which people make modifications to their agreements as they go forward, and substituting in an LLC for an individual is about as unusual as, I don't know, snow in January. But whatever the trial court stated as a reasoning is immaterial. At the end of the day, it was reasonable, and it was in the scope of the discretion of the trial court. I appreciate the court's time. Are there any questions?
Nothing more from me.
Thanks very much. Ms. Parker, any rebuttal?
Just briefly, I think the difference between this case and the instance of Solomon is Solomon wasn't dealing with basic contract law. And that's what we're really talking about here, is just an application of pure contract law. And how do we amend contracts? The parties to the contract must amend it. And so I would ask the court to look at it from that perspective. Thank you.
Thanks very much. That case will be submitted. Have a good day. We'll move on to our next case, which is item number 24, docket number 368366, the State of Jason Allen versus Arbor Springs Water Company. Good morning.
Good morning. Good morning, Your Honors. May it please the court, Brianna Combs on behalf of defendant appellant Arbor Springs Water Company. I would like to please reserve time for rebuttal, and I will keep track of my own time. I know Your Honors are familiar with the record and with tort law. Here we have the Arbor Springs driver, Derek Hasselback, who discharged his duty admirably and safely pulled the Arbor Springs truck off the road immediately when he detected a problem so as not to put anyone on the road in harm's way. At trial, the jury found that Mr. Hasselback was not negligent. This should have ended plaintiff's case against Arbor Springs because the only two claims pled in plaintiff's complaint against Arbor Springs were claims for vicarious liability under the doctrine of respondeat superior and ownership liability, which both require plaintiff to prove negligence on behalf of Arbor Springs driver. Hasselback testified unequivocally at trial that he was assigned to this truck 35, and that he was the only one to drive this truck. Hasselback was responsible for the truck. He inspected the truck the night before the accident, including getting underneath the cab of the truck and underneath the front wheels, and he found no problems with the truck, no problems with the front wheels, and no problems with the right front wheel. Whatever duty Hasselback had, he discharged that duty when safely parking the truck in the movie theater parking lot.
Well, I mean, the jury found that Hasselback was not
Correct.
negligent. So, I don't think we need to sort of rehash whether he was or wasn't negligent. I think the issue is that Arbor Springs vicarious liability could, in theory, arise from the negligence of a different employee. And I think here we're probably talking about the maintenance guy. I'm sorry, I'm suddenly forgetting his name.
Mr. Schramm.
Schramm, right? And so I think that's, given what the jury decided, which is that Hasselback was not negligent, I think that's the question before us, is whether there is evidence from which a reasonable jury could find Arbor Springs liable because of his negligence, Schramm's negligence.
And my primary response to that, Your Honor, would be that that is not causally related to the accident. Anything that happened in the warehouse months earlier is not causally related to this accident. The fact here is that on the day of the accident, Arbor Springs safely removed this truck from the road, and there was no harm done to anyone. Anything that happened months earlier in December of 2018 or before that, simply there's no causation linking that to this accident. And
You don't think the expert's testimony about, buying used wheels and, having them installed, or Schramm's testimony about not following the owner's manual, that wouldn't allow, I mean, I'm not saying I would decide, but wouldn't that allow a reasonable jury to infer that there was a causal relationship between Schramm's acts or omissions and the accident?
no, Your Honor, there's no law obligating Arbor Springs to use new wheels every time they replace wheels on the truck. There's no duty here to use new wheels as opposed to used wheels. And we have the Schrader Tire and Oil Manager, Jamie Ortbrigg, who was the wheel and tire expert in this case, who testified that they installed 2 wheels in June of 2018, and he testified that he was satisfied that that those wheels had no cracks and were roadworthy. So any attempt to try to point to, oh, they use used wheels, there's simply no duty to use new wheels. And there's this argument about failing to perform a pre-route inspection, but Hasselbeck did, and the testimony shows he did inspect the truck the night before the accident and found no issues. And I think it's key here also that there's no record evidence that anyone at Arbor Springs ever saw any crack in any wheel on truck 35 before this accident.
Now, there is no rule against purchasing used wheels, but didn't the owner's manual advise against that?
Yes, Your Honor, I believe that there was some language in the owner's manual, but again, that would be an internal owner's manual that cannot prove negligence in this case. I think the law in Michigan is clear. It's well settled that a violation of your own internal rule can't prove negligence.
Well, it doesn't create necessarily a standard of care, but it can't provide, is your position that it can't provide any evidence at all? It's not relevant at all, or just that it doesn't provide the per se standard of care?
No per se standard of care, Your Honor. And I think it's important to kind of look at this. And I think if any one of us had something wrong with our vehicle, which I'm sure many of us have, and then called a tow company and put the vehicle in the tow company's hands, and the tow company towed the vehicle incorrectly, I mean, it's illogical to say we are responsible for the tow company's negligence. And I think that's the kind of the crux of this case.
Now, the verdict apportioned responsibility. It wasn't right. The verdict reflected an apportionment of blame, I guess, for this. Is that right?
Yes, there was 60% to Arbor Springs.
And 40% to the.
And Brewers had settled prior to trial, but there was some apportionment on the verdict form, yes.
My understanding of how the law breaks this up is that if there's gross negligence, that can be what we call a superseding or intervening cause, and it can break the chain of causation. But if there's just simple negligence, that's considered, under the law at least, reasonably foreseeable. And so looking at, I mean, you can take issue with that and let me know if you think that's not how it works, but looking at Brewer's conduct of towing the truck by the front rather than, or by the rear rather than the front, that seems to me like it's at most regular negligence rather than gross negligence. And that seems to be relevant to whether you can say that, you know, there was a chain approximate causation between the Arbor Springs conduct and the towing situation.
Your Honor, I'd like to correct the rule a little bit on the gross negligence focus. The rule says an intervening cause breaks the chain of causation and constitutes a superseding cause which relieves the original actor of liability unless it is found that the intervening act was reasonably foreseeable. So that the reasonably foreseeable is what we would look at here. And I think it's absolutely not foreseeable that a reputable tow company, and there's testimony in the record, that Arbor Springs had a relationship with this Brewers Tow Company for 25 years. Mr. Schramm testified, I've been working with them since 1995. And it's absolutely not foreseeable that this reputable tow company would do the exact opposite of what Mr. Schramm instructed. Mr. Schramm, after learning about Mr. Hasselbeck pulling off the road, made 3 calls. He called Chad Brewer at Brewers Towing. He called another individual at Brewers Towing, advising both of them, I have a truck pulled off the road with a cracked wheel, and you need to tow this truck from the front with the front wheels off the ground. There's record evidence showing that the dispatcher put that exact note in her dispatch notes, but that was not relayed to the tow truck driver because he did not have the proper application on his phone. So we would absolutely argue that it's not foreseeable that this reputable tow company would have this negligent string of actions when Arbor Springs has been working with them for 25 years, and Mr. Schramm testified, I've never had a problem with them for 25 years.
So counsel, I mean, is it your argument that, ordinary negligence as a matter of law can provide a intervening cause? Or is your argument that what we have here wasn't ordinary negligence, it was gross negligence?
My argument would be that yes, ordinary negligence can satisfy that.
Is there any, because I feel like I feel like we have law indicating otherwise. So is there any law that you have that you can point us to that indicates that recognizes sort of the ordinary negligence you're looking for us to use as an intervening cause as being a legally viable path?
I think just the rule that I just read, I mean, that's what we relied on in our brief, that there's no distinction in that rule between ordinary and gross. It's just whether whether the intervening act was reasonably foreseeable.
Okay.
And absolutely here we say that it was not foreseeable. And I think it's important here to think about this as I kind of presented that hypothetical. Ruling against Arbor Springs here would create a rule that impacts all of us. Is every individual going to be held responsible for an improper tow? And I think the law does not hold actors responsible for doing nothing wrong.
Well, it's not that you did nothing. It's not that they did nothing wrong. I mean, if this is moved, I mean, I know that's also your argument that they did nothing wrong, but
Right.
The proximate cause issue is about someone does something wrong and then someone else
Right.
does another thing wrong.
Right.
And do they both have to, are they both liable, or does the second wrong thing kind of break the chain of causation from the first wrong thing?
Right. Correct.
So
And that's what we have here.
So I mean, all of us, I think, are, potentially liable when we do something wrong. The question is, if someone else does something wrong later, does that kind of, relieve us of ultimate liability?
Yes, I would agree.
Okay.
Unless your honors have any other questions, I'd like to save my time for rebuttal. Thank you.
Okay, thanks so much.
May it please the court. My name is Elizabeth Arco, and I'm here today on behalf of Patricia Allen and the family of Jason Allen. Your honors, I would like to start with respectfully, Arbor Springs is not like all of us. Arbor Springs is a commercial truck vehicle owner. They owned 12 commercial vehicles that they drove and put out on the roads in Michigan since 1926. At the time of this incident, they had been operating commercial vehicles in this state for nearly 100 years. And what we have here, I want to start first with Mr. Hasselbeck's negligence. The finding of not negligent is not dispositive of the claims. Plaintiff has 3 claims. They had 1 claim against Mr. Hasselbeck, and then we have 2 claims, vicarious liability and owner's liability. The owner's liability is not vicarious. We cited law in our brief saying that that statute is not a vicarious. So Mr. Hasselbeck's negligence does not obviate owner's liability, and Arbor Springs didn't make that argument at the trial court, and we would continue our position that that has been waived. But as to the vicarious liability, Your Honor talked about Mr. Schramm. Mr. Schramm's conduct and negligence did not start the day of the accident. It started days, weeks, months beforehand. It was not in 2018. It was well before that. He made the decision to have junkyard wheels, which, as Your Honor pointed out, was against the owner's manual, specifically said it could fail without warning. Then he was not trained as a mechanic, yet he performed all of the maintenance on these wheels in-house using an improper tool at an improper torque. And then the jury heard evidence that that torque was responsible for causing the cracks. Then this vehicle was making noise for 3 days before the incident. And Mr. Mr. Schramm made no requirements that anybody inspect this vehicle. You heard from counsel that Mr. Hasselbeck was satisfied with the inspection, but really what actually happened was he testified that he did not actually look at the wheels. He did not look at the wheels on the day of the incident, and there was expert testimony that these would have been visibly cracked. And so Mr. Schramm let the vehicle go out on the road. Then Mr. Hasselbeck pulled it into a parking lot, and Mr. Schramm made the decision, even though, as Arbor Springs expert testified, when that wheel was in the parking lot, it was in a hazardous and defective condition. And Mr. Schramm made the decision to have the vehicle towed. He could have used roadside assistance. The jury heard extensive testimony from all experts that had this wheel not been moved and had roadside assistance been used, Mr. Allen would still be alive today.
Does that go to, I mean, I guess, are you saying that the decision to tow it was a negligent one, or is that just a matter of causation? Tell me how that fits in.
I think I think it goes to both. I
What was
think
negligent about the decision to tow it?
Well,
I understand why, and in retrospect,
sure.
maybe not, but.
Well, I think it could speak to a common law duty as to whether or not that was reasonably imprudent under the same or similar circumstances. But also, we have a statute. There are 3 statutes at play that played a big role in this case. And Michigan Rule 257.683 says that a vehicle shall not be driven or moved in a defective condition. And we have expert testimony from Arbor Springs expert that when it was sitting in that parking lot, it was in a defective and hazardous condition. And the decision by Mr. Schramm was still made to have that vehicle towed. And it wasn't to call the dispatch company directly. It was to call the owner and ask the owner to relay the information to the dispatch driver, who the dispatch driver then told the tow truck driver. And so what we have here, to come back to your question, this also plays into causation because this was reasonably foreseeable. This is general negligence. As Your Honor pointed out, there is Michigan law that is controlling that says ordinary negligence is reasonably foreseeable. And in the Comstock case, what the court said, what the Michigan Supreme Court said, was when you set a chain of events in motion, the negligence of a third party is not going to break the causal chain. And in that case, they said it was human error. And that is exactly what the jury heard here. The jury heard evidence that Brewers made a mistake, and they apportioned 40% of fault to Brewers. But that did not break the chain of causation. So I think the decision to have the vehicle moved, the decision to have it towed, plays both into duty because we have a statute at play here, but it certainly always also ties in to causation. And so, Your Honor, there were multiple arguments made about duty, and we would just want to come back full circle. So Mr. Hasselbeck's negligence is not dispositive of any of these issues. And so the question then is the verdict as to the negligence. And as we have said, we think the jury heard ample evidence on breach and causation, that this was not an intervening superseding cause. This did not break the causation, that they were joint tortfeasors. Arbor Springs made the decision starting months before this incident and through the day of the incident, that put the defective wheel on the road. And then that piece, there is no question, was the piece that unfortunately killed Mr. Allen. And so we think that this was properly a jury question, certainly when the facts are viewed in the favor of the estate, as they have to be. The jury heard ample evidence to come to that conclusion. And there's duty, both common law and statutory. I think we extensively briefed that in our brief, but I'm happy to answer any questions. The other thing I do want to touch on is the remitter, because we have 2 arguments here. That's an abuse of discretion standard, and Dr. Hunter gave the jury extensive testimony that Mr. Allen experienced conscious pain and suffering. He described it as not being an on and off switch. He made it very clear that Mr. Allen was suffering, and he was in pain for that full hour. Arbor Springs has cited other testimony. We don't dispute that there is a Glasgow coma scale, but Dr. Dr. Hunter was asked about that, and he explained why he didn't think that that impacted or changed his opinion. He gave an expert medical opinion on those documents. And Mr. Reeser, the jury also heard, he did opine that he was unconscious, but he wasn't with Mr. Allen the whole time. The jury heard a very different testimony when you look at the full cross-examination of Mr. Reeser, in that he was going for help. He was under distress as to what he just saw. So the jury was the one that was in the best position to weigh the credibility of the evidence that they heard, and they properly found that there was conscious pain and suffering, and the amount should not be disturbed. So unless there's any other questions, I would ask that the judgment be affirmed.
Any more for me? Yep.
Okay, thank you very much. Your rebuttal?
Yes, thank you. I'd first like to address Mr. Schramm and go back to his testimony during trial. Mr. Schramm testified that the first time he learned of any issue with the wheel on truck 35 was the day of the accident. He testified he never noticed a crack at all before the accident. And he testified that when he serviced the truck just a month before the accident, he did not notice any cracks in the wheel at that time or any other issues. Counsel mentioned hearing a noise for days before the accident. That is factually incorrect. Mr. Hasselbeck testified at trial that he heard a single noise just once before the accident. And after hearing that single noise, he inspected the truck. He not only got underneath the cab of the truck, but he got underneath the front wheels. So to suggest that he did not inspect the wheels is also factually incorrect. And again, I think Your Honors asked about this, failing to stay with the truck. There's no duty in Michigan to stay with a truck. We have testimony from Douglas Rowland, who's done over 1,000 tows, and he said this is standard practice in the industry for someone to leave the keys with the vehicle in this type of situation. And then as to the vicarious liability claim, plaintiffs are arguing, well, we're not just looking at Mr. Hasselbeck, but plaintiffs have not identified any negligence by any Arbor Springs employee. Mr. Hasselbeck was found not negligent, and there's no other Arbor Springs employee that was negligent. Corporations act through their agents, and there's no negligence of any agent of Arbor Springs here. And as to the statutes and regulations, if these regulations even apply, which was a matter of legal dispute at trial, what they require is for the driver to be satisfied. And the record shows that Mr. Hasselbeck inspected the truck, saw nothing wrong, saw no cracks, and then pulled over immediately. So there's no violation of the statute or of the 2 federal regulations. I'm sorry, just wanted to also address the remitter argument briefly. And I went back and read plaintiffs' 2 experts' testimonies at trial. Neither of those experts testified that Mr. Allen was conscious. Dr. Hunter did not treat or observe Mr. Allen after the accident. And Dr. Hunter never testified outright that he was conscious. He testified that Mr. Allen was in an unconscious range and that he does not know where Mr. Allen was in that range. And again, plaintiffs have the burden of proof on this claim, and they have to prove by a preponderance of the evidence that he experienced conscious pain and suffering, and they did not do that here. Is there any other questions that I can answer? Thank you.
Thanks, Counsel.
Thank you both very much. That case will be submitted. Moving on to the next item, it's item number 25, docket number 371892, Elizabeth Lowry versus Nathan Lowry. Good afternoon. Oh, hold on 1 minute.
I think you're right. Actually, this is high enough. I don't actually need this. I appreciate you allowing the blind guy to set up his teleprompter here. I guess it is good afternoon, and may it please the court, Jason
Welcome.
Killips on behalf of Alyssa Lowry. We're here today because the circuit court interpreted the Domestic Relations Arbitration Act
to allow a party to invalidate an otherwise valid and enforceable prenuptial agreement containing an agreement to arbitrate because of later arising allegations of later occurring domestic violence. Now, to be clear, the allegations of domestic violence here, which my client will dispute if she's ever given an opportunity to do so, these allegations are that the domestic violence occurred more than a decade after the prenuptial agreement, which includes the arbitration clause that we're talking about, was formed. So there is no allegation in this case that the agreement to arbitrate was tainted or coerced or made under duress related to domestic violence in any way at all. Nevertheless, the circuit court found, and Nate continues to argue, that this later allegation can retroactively invalidate the agreement to arbitrate. That's wrong, and here's why. When the legislature enacted the DRAA, it enacted a structure that tracks the way cases come before courts before they go to arbitration. What I mean is that a case ultimately destined for arbitration can come before a court in one of three postures. Scenario one, the parties long ago or a couple days ago or years ago agreed to arbitrate. And the parties are both still happy to arbitrate. Well, in that situation, the court need do nothing. Under section 5071 of the DRAA, those parties stipulate to arbitration. In fact, their agreement may already be a sufficient stipulation. And no act of the trial court is required. Case goes to arbitration. Scenario two, you've got that agreement to arbitrate. It's days, weeks, months, years old. And now one of the parties no longer wants to arbitrate. And now a circuit court is asked, to order the recalcitrant party to nevertheless do what it agreed to do and to arbitrate. The DRRA addresses that in section 5072, subsection 1, which explicitly addresses a situation under which a court is to order a party to participate in arbitration. That's the phrase that it uses. And then the third scenario is when the parties haven't agreed to arbitration at all. When they come before the circuit court, and at some point the circuit court determines, you know what, I think some or all of this case is a good candidate for arbitration. So I think you parties should go talk to, pick your favorite domestic relations arbitrator, and see if you want to agree to arbitrate your dispute with this person. That is a referral to arbitration. And that is covered by the DRAA as well under section 5072, subsection 2. Now, we have greater tests that must be met before a court can refer a case to arbitration under subsection 2 than we do under either 5071 or 5072, subsection 1. And why is that? Well, that's because in the other two cases, the other two scenarios, scenarios 1 and 2, we already have an agreement to arbitrate. But we have to be more careful when we don't have one, which is the third scenario, because here the parties are going to be sent to potentially form an agreement to arbitrate, and we need to make sure that they are actually free to do that. And so when we do have allegations of domestic violence, or there is a PPO, or some of the other situations that are mentioned under subsection 2 of 5072, then courts are cautioned, in fact, they're instructed not to send those cases to arbitration, not to refer them to arbitration, because it's entirely possible that later on in the process, somebody's going to claim the agreement to arbitrate was not freely made. And we want to avoid that situation. So that's the structure we have here. How does that apply to this case? Here we are in subsection 2. The parties long ago formed an agreement to arbitrate. When we got to the circuit court, all of a sudden, Nate said, I don't want to actually arbitrate anymore. I don't want to follow the agreement that I made. And so Alyssa filed a motion to order Nate to participate in arbitration. This squarely falls under section 5072, subsection 1. There is no dispute that the requirements of that subsection were met, and that should have ended the circuit court's inquiry. The court should have granted Alyssa's motion, ordered Nate to participate in arbitration, It didn't do that, and that was error, and it should be reversed. Now, Nathan's arguments all rest on two widespread and consistent mistakes. He's wrong about two things here. First, there is this assumption throughout his arguments that referring a case to arbitration, the language in subsection 2, means the same thing as ordering a party to participate in arbitration, which is the language in subsection 1. That can't be true. We know it's not true because those are very, very different phrases. They appear within a couple lines of each other in the statute. So if the legislature had intended these two subsections to mean the same thing, or for those two phrases to mean the same thing, they would have used the same language. But these phrases aren't slightly different. They're very different. They have different verbs. They have different objects of those verbs. They have nothing to do with one another.
Counsel, can a court refer a matter to arbitration without entering an order to that effect?
Absolutely.
So how does that referral get effectuated?
Well, the court can't order parties to arbitrate unless they've already agreed to do it. Arbitration is inherently a creature of contract. So a court can suggest you guys go talk to Mr. Smith or Miss Jones or whoever to explore arbitration, but there can't be an order to them to go arbitrate. It is simply a referral. So the fact that the court was that the legislature used these different phrases in subsection 1 and subsection 2 indicates that they meant different things. But the other way, or the other reason that we know that, the other main argument that Nate makes throughout that is also wrong is when he says that every case that ends up in arbitration has to have been referred there. There is always a referral to arbitration. That's not true. In fact, it's rarely true. First, when we're operating under the situation, which happens all the time, where parties come to court with a previous agreement to arbitrate and they are following that agreement, they're going to participate in arbitration. The only thing that 5071 says that the parties have to do is stipulate. There is actually nothing under 5071 that requires the court to do anything. There is no extra step. There is no required step of a referral, as you were asking about, Your Honor.
I guess so in 5072, in subsection 1, it says the court shall not order.
Yes.
The court couldn't order, presumably without an agreement underlying, right? So in a court, I guess, are there circumstances when a court orders a party to arbitration that don't constitute a referral arbitration? I mean, I understand a lot of the statutory interpretive argument here is on a strong distinction that you're drawing between what an order is and what a referral is. And I understand your point that those may not be, perfectly congruous terms, but I guess we're taking the proposition that they aren't equivalent terms into one that suggests they mean a very specific distinction that you're suggesting. And I'm looking to find, I'm trying to figure out where all of the support for that is, aside from understanding just sort of how you feel like perhaps, the legislature may have felt it should work. So, I mean, is the, when the court issues an order to arbitration, is that not a referral? Or tell me how you think about that.
I think of that as an order.
But why is it not a referral?
Because a referral must mean something else, or we would use the same term in the statute to define.
And I guess, are there other places where the court obviously we have a lot of statutes and a lot of court rules about arbitration.
Absolutely.
If I look to those, am I going to find this sort of distinction between referral and order and how we talk about arbitration in courts, responsibilities and actions with respect to it, that's going to substantiate sort of the distinction that we're seeing in your argument here?
I think the direct answer is no, but that's because we don't see the word referral show up in the context of arbitration almost anywhere else in our law. There's no case that I'm aware of defining what a referral to arbitration means. And nor does that phrase show up in any other statute that I'm aware of dealing with arbitration. Probably that's because arbitration, being a creature of contract, Courts can only order parties to participate in arbitration under one circumstance and one circumstance only, and that's where they've previously agreed to do it. But then what you have is a referral to arbitration. If the parties are already happy to arbitrate and they've submitted a stipulation, there is no further step necessary. If we say that there also must be a referral to arbitration, then we are adding a procedural step under 5071 that the legislature didn't add. I mean, the analogy that keeps coming to mind actually is this court's own rule, MCR 7.212. If I want an extension for, to file my brief, the first extension, 28 days, I call up Ms. Ardroff and say, would you agree? And if she does agree, we enter a stipulation because the court rule says we just have to stipulate to that. This court then doesn't enter an order. It doesn't take any other action. The clerk's office takes note of the stipulation and moves the deadline 28 days. Similarly, 5071 doesn't require anything else. If the parties stipulate, that's the end of it. There need be no referral or passing of the case or whatever other term you want to use. Nothing else is necessary once you have that stipulation there. So to create this requirement that if the parties stipulate, then the court can refer if section 5072 sub 2 is satisfied, is to write something into 5071 that doesn't exist.
And 5070 or 5071 and 5072 sub 1 pertain to domestic matters, domestic relations matters broadly.
Yes.
Which, you know, include but aren't limited to those involving allegations of domestic violence. Correct.
Correct.
So the only one that we have specific to that is the 5072 sub 2. That's the one that speaks specifically to.
With one technicality, yes, you're right, Your Honor.
Okay.
The only technicality is subsection 1 of section 5071. This case is the statutes are a mouthful.
5072 sub 1.
Thank you.
Yeah, it mentions.
It does have a warning about
Right,
domestic violence,
but it sounds like you're supposed to provide that warning in a domestic relations matter.
Yes.
So regardless of whether there's allegations involved of domestic violence, it sounds like that's part of the pro forma warnings.
It is.
Okay.
Yep, absolutely. But if the court, or excuse me, if the legislature had intended to go so far as to say, we're going to take cases in which there are later arising allegations of domestic violence and treat those cases totally differently, we're going to keep them away from arbitration. The court or the legislature could have done so. It did that under section 5072 sub 4 for child abuse and neglect cases. It could have also said child abuse and neglect cases and cases in which there have arisen allegations of domestic violence shall be excluded from arbitration under the act.
Right, and I understand opposing counsel's position. We'll hear from them is that, well, right, they decided they didn't want to go quite that far, but they decided to say, well, we're still going to allow it when there's allegations in play, so long as we go through this process to confirm at that moment that everybody is actually okay with it, regardless of what they may have said before or what they're saying. You know, we need to go through this process because, you know, domestic violence can come with power imbalances that can influence not just the original agreement, but also the process that you'd be undertaking at the time.
And I certainly understand that that is their argument. I don't agree that the statutory structure reads that way, nor do I think that the policy that the legislature was trying to enact would make sense to go quite that far. If what they wanted to do was to say, anytime there's been an allegation of domestic violence, even if it is years after the agreement to arbitrate was made, then a court shouldn't order a party to participate in arbitration unless certain tests are passed. They would have moved that up into subsection 1. Or they would have used, we won't order a party to participate in arbitration when, and written that out in subsection 2. But they didn't do that. And I think the reason they didn't do that is because really in the context of arbitration, the only reason that domestic violence or allegations of domestic violence becomes relevant is whether the parties are able to freely agree and form an agreement to arbitrate. Once we're past that step, arbitration looks like litigation, at least as far as.
I mean, you choose your arbitrator, right?
You choose your arbitrator, and the provision, the agreements have, or excuse me, the arbitration agreement has a provision for that. right? The one in this case has that agreement. If they're required, in fact, I believe the stipulation under 5071, I'd have to double check it, but I think you actually have to have your arbitrator chosen under that process as well. But yes, there's a few things you have to agree to, but once that arbitration has begun, once you've got the structure in place, then it looks like litigation in the sense that you have a impartial, neutral third party deciding the issues in dispute. This is why this court in the Mann case, it's cited in our brief, it's an unpublished opinion, but this is why that case highlighted the important difference between mediation and arbitration in the way that the procedures are implemented to protect alleged victims of domestic violence. When we're mediating, throughout the goal is an agreement, right? A successful mediation ends with a settlement agreement. And mediators, therefore, are charged with making sure that they run domestic violence screenings. And they do that for a reason, because if we have a successful mediation, it has to end with the parties shaking hands, and we want that agreement to be enforceable. That's not at all the case in arbitration, just as in litigation.
Doesn't arbitration also often involve some very informal procedures and settings? I mean, it seems to me that you obviously make a compelling argument about when an agreement to arbitrate is being made, there's a state interest in sort of, providing some protections around voluntary versus coerced types of agreements, and domestic violence can sort of interfere with that. But there's also an argument, I think, to be made that the actual setting of arbitration may be disadvantageous when there's domestic violence going on. For example, you might be in a private setting that's not that's not a courtroom. There may not be security type of presences there. There's you may be expected or pressured to physically shake hands. Those kinds of things are less likely to happen in a courtroom probably than an arbitration environment. Now, we don't know what the legislature, right? We don't know exactly what they were thinking and why they.
All we have are their words, right?
All we have are their words. But I just wanted to sort of question you a little bit about this assumption that the only reason to have state interference here is at the moment of the agreement to arbitrate, as opposed to at the moment of the arbitration / adjudication.
Sure. And I certainly appreciate that, but this court has recognized in a few recent, actually, unpublished opinions. Your Honor sat on the DeClercq case, came out, I think, only a couple months ago, where it recognized that the arbitrator in that case had actually taken extreme steps, because there had been a history of domestic violence between the parties, to make sure that much of it was conducted by Zoom, so the parties were never physically in the same place, that he held arbitration through what they called the caucus system, where instead of hearing from both people like a court normally would, that he would hear from one person in one room, and then he would proceed to another room to keep the parties separate, hear from the other side over there. So arbitrators have a lot of flexibility and a lot of tools available to them if they need to keep people apart, if they need to keep them feeling safe. They absolutely have the flexibility to do those things. But also, if we were so concerned that that was a big problem and a reason to keep cases involving allegations of domestic violence out of arbitration, then I think we would have seen some of this court's precedent, unpublished, non-binding, we're in family law, but precedent decided differently. Both the Bies Rice and the Dowd cases involved situations where domestic violence arose during the arbitration process. And so the court said, well, look, you brought it up later. You'd already started arbitration. We're not going to interfere there. We're going to enforce the arbitration award, and this court affirmed those decisions. But if later arising domestic violence, even during the arbitration process, raised the concerns that you're raising, Your Honor, I think then the courts would have instead stepped in and said, no, we've got to put a stop to this. Now we have reason to think that this whole process, including this arbitration award, is invalid. we need to send this back to a circuit court to deal with. That didn't happen. In fact, I'm not aware of a single case in which an arbitration award was invalidated on those particular grounds.
I guess, I mean, the statute also doesn't, I get, if I were a court, I would look at the statute and say, well, my point of intervention here is at the commencement of arbitration to make sure that we're all good to go. And then once it starts, I may have cause for concern, but I don't know if I would be able to look to the statute as providing a means to intervene.
And that is fair. Procedurally, I think it would be a little bit more difficult for exactly the reasons you point out, Your Honor. But this court never expressed any even concerns with the fact that the arbitration was going forward with these allegations. I think one case even involved a PPO pending for a minute or two, even though that was later dismissed. But there was no procedural concerns raised with how the arbitrations had proceeded.
Now, parties can amend an arbitration agreement,
Of course.
like any other contract. Seems to me, and this isn't negating your point about refer versus order, but it does seem to me that part of subsection 3, the waiver and consent situation, allows for, so let's say, the original arbitration agreement said nothing about Zoom versus in person. Then there's a domestic violence allegation that arises. The parties could say, look, we are going to agree to arbitrate, but we need to amend the arbitration agreement to say only Zoom. And if we do that, then I will consent. To continuing the arbitration. So it seems like this subsection 3 provides a little bit of a window or a little bit of a buffer for the parties to sort of renegotiate an arbitration agreement if there's a domestic violence situation.
Although I think in that situation, Your Honor, we'd actually be back under 5071. Because now if the parties have agreed to change their provision, but have still reached an agreement to arbitrate and both are willing to move forward, now all they have to do is stipulate. And
right, but an amendment requires both parties to agree.
Yes.
And subsection 3 provides a little bit of subsection 3 would allow one party to say, I'm not going to consent until we make an amendment to this agreement.
Well, but then the other party either agrees to it or they don't. Right. So then once you have both parties agreeing, now you're back under 5071, they stipulate and they go to arbitration. I mean, I certainly understand that you could look at that statute as an invitation for the parties to solve this together. And hopefully courts, I think family courts do this a lot where they do encourage parties to try to find ways to solve this together. So I'm certainly supportive of the idea that a circuit court may look at that and use that as a lever to help the parties find a way to move forward. But I think that procedurally in statutory construction nerd speak, which is how I usually approach these things, I think we'd fall back under 5071 at that point. Unless the court has any other questions, I'll save the rest for rebuttal.
Okay,
No,
thank you very much.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court? I'm Karen Sandelbach, here with my co-counsel Ann Argeroff and my client Appley Nathan Lowry is here with us today as well. And I'm here to discuss the reasons why the trial court was correct in its interpretation and application of MCL 600.5072. Which served to protect the parties, particularly Appley's constitutional rights, to have his dispute heard by the trial court by refusing to order arbitration of a family law case when Appley raised allegations of domestic violence in his first filed pleading, and he has consistently declined to waive the domestic violence exclusion contained in Michigan's Domestic Relations Arbitration Act, codified in MCL 600.5072. For simplicity throughout my argument, I will refer to the statute as 5072 or the Domestic Relations Arbitration Act. Judge Marinari, I'd like to respond to one of the questions you asked. And in domestic relations, courts refer through orders. I'm unaware, having practiced family law for 30 years, I'm unaware of a court ever referring anything to any agency, whether it be friend of the court, arbitration, friend of the court.
But opposing counsel seemed to contemplate a scenario where it was, very informal, kind of saying like, why don't you two consider arbitration? Is it your position that that's not a referral?
It might be a recommendation, but in order for the parties cannot stipulate to derogate judicial duties, Your Honor. The circuit court has a responsibility to litigate all matters, to make all decisions in family law cases, unless and until the parties voluntarily decide that they want to ask the court to stipulate, to ask the court to refer their matter to arbitration. But if they ask the court to do that, only the court can agree to send a matter to arbitration, and only after applying all the law is contained within the statute 5072. And the court can only do that through the order. Your Honor, if we look through, starting at the very caption of that statute, which has been the same since 2001, the statute is court order to participate in arbitration. Court order. It can only happen through an order. And we know through decades of statute that parties cannot stipulate to derogate official or court responsibilities. Parents cannot even independently decide who will have custody of their own children without a court blessing that decision on their behalf. A court has to make that order.
And counsel, I asked opposing counsel similarly, what's the best way for me to know that this is the right way to think about these two terms? Obviously opposing counsel's position, makes a significant point about the distinction between the terms. I understand your point is that that's just not the case. And, are there other places that we can look to in terms of the court rules, in terms of statutes, to help us make sure we're understanding sort of how the legislature may have been thinking about these two terms it chose to use for whatever reason in this statute? It makes sure we're thinking about it the right way too.
Sure. If you look at the amicus brief that was filed by the State Bar of Michigan's Family Law section, they talk about the distinction of the language that the court makes referrals through court orders, and talks about the FIA and the friend of the court. And I think they give some good examples there of how the court makes referrals through court orders.
So from your perspective, is that the best authority?
Yes.
Okay.
Yes, Your Honor. But nothing can happen in court without a court order. All referrals are made through court orders. And I think if it's important for us to look at the case of Grand Rapids versus Crocker, which we state in our brief, that says that you have to look at the entire statute, that no statute can be looked at out of context, that you have to look at the language of an entire statute. And when you look at the 5072 and you have to look at the entire statute. And so Section 1 of that statute is the warnings which must be given to the parties before the parties can even approach a court and say, Your Honor, we would like you to refer our case for arbitration. The attorneys have a responsibility, either on the record or in writing, to give those parties warnings. And interestingly, one of the warnings is that arbitration is not recommended for cases involving domestic violence. And
But those warnings were provided in the prenup agreement.
In the prenup,
right?
12 years.
Oh, sure. It was a long time before, but they were there.
Yes, and one of the things the trial court judge brought up was that a knowing warning? And we didn't have to get to that. because the case then failed for order of referral in section 2. So the judge didn't really have to dig into that because Mr. Lowry declined to waive the domestic violence exclusion protection. So the judge didn't have to get, I would argue that that was not a knowing warning because it was predated the actual domestic violence. But yes, so, and the parties were not, at the time of the prenuptial agreement, the parties were not party to a domestic violence case as required because of the language in section 1. But let's say that they have made those warnings, they have received the warnings in writing or on the record. Then the court proceeds to section 2, where the court has to determine then, are they subject to a personal protection order? Or are there allegations of domestic violence or child abuse? The judge then went through that analysis and said, yes, in this case, and it was uncontested. It's uncontested in this case, there were allegations of domestic violence. We then get to the unambiguous statutory language, which has been the same unambiguous statutory language since the statute was passed in 2001. The court shall not refer the case to arbitration. Shall not. Unless each party to the domestic relations matter waives the exclusion. And I think it's important to note that in the parties' prenuptial agreement, they agreed that any arbitration would be subject to the DRAA. They agreed that this statute would apply. Now, there's no way they could have waived in their prenuptial agreement because, number one, it couldn't have been a knowing and voluntary waiver because the domestic violence had not yet occurred. Certainly, you couldn't waive in a knowing way something that you didn't know about. They weren't parties to a domestic relations action yet because nothing had been filed. It was 10 years prior to the filing. It couldn't have happened on the record. There was no record. A judge couldn't have approved it. There was no judge assigned yet. So none of that could occur in a prenuptial agreement. But here we are, fast forward 12 years. Now they're standing in front of a judge. Now this case has happened. So the judge says, yes, I understand that there are allegations. Yes, you're standing in front of me today. Do you waive? Mr. Lowry said, no, I do not waive. Well, the matter is now resolved, right? The judge, according to the statute, is unambiguous. The statute says the judge shall not refer. So whether it says order, whether it says refer, it shall not happen. The statute says the court shall not refer. Even if Mr. Lowry had said yes. Now, this is just an interesting academic argument, but even if he had said yes, even if your honors were to find that the prenuptial was enough, and he had said yes, then the judge would have still had to continue on and do more analysis. The judge would have had to make sure that he was appropriately informed, that it was a voluntary waiver, that it was a knowing waiver, that he understood that arbitration is not just like litigation, that arbitration may include the suspension of the formal rules of evidence, that arbitration is significantly more binding than litigation. There is really no meaningful right of appeal, that the circuit court judge has a duty to uphold the arbitration award, even if the rules of evidence are not filed, even if there maybe is coercive control, even if there is no Zoom arbitration, even if there's irregularities, even if unfair things happen, even if the law is not applied. Unless there are very unusual things that happen, essentially, unless the scope of the arbitration is exceeded, the court has very little ability to not endorse the arbitrator's decision.
Counsel, I feel like opposing counsel, as a point made in the brief, that this really kind of, leaves little left to, agreements in a posture such as the one at issue here, a prenuptial agreement that predates any domestic violence. An arbitration provision is in there. And and as I understand counsel's position, there's a concern that this, basically leaves those with very little space to operate if we read it to foreclose arbitration down the road, should things go sour and should, I don't know if we've defined the scope of what constitutes an allegation of domestic violence, but I know that doesn't seem to be a dispute that is present here. But I guess what of the point that this, this interpretation would leave, too little effect to, a binding contract provision in a recognized form of dispute resolution.
I'm sorry, I don't understand your question.
Okay. I think opposing counsel says that this is kind of a get out of arbitration free card. I think if I'm remembering right from the brief. And what we have is an agreement that, at present, we haven't, let's just assume knowing involuntarily entered into. I know you dispute that, but you have a prenuptial agreement. Both parties have agreed to arbitrate. And then if all that's needed is, an allegation of some form of domestic violence down the road to, eliminate that agreement, what is the, how do we know that the legislature intended to constrict that ability to contract? So again, I think in counsel's perspective, so severely.
Well, at the time that the parties entered into the prenuptial agreement that included that arbitration clause, they specifically agreed that the Michigan's DRAA would be applied.
If they hadn't, would that matter?
Well, no, I suppose it wouldn't, because Michigan's DRAA would apply anyway. But it shows that they knew that, and they knew that at the time they agreed to that, they specifically knew that Michigan's DRAA included prohibition against arbitration.
But I mean, I guess
if there was an allegation,
what if they didn't? What if they didn't know that at the time?
It would have applied. It would have applied, but they were specifically acknowledging that they knew it applied. And that now I suppose you're saying, what if somebody cynically made an untrue allegation of domestic violence because in hindsight, they wish they hadn't agreed to arbitration? Well, I suppose if that came out at trial, then what was the harm? What is the harm if they do that? I suppose their case ends up being tried in the trial court like most of Michigan citizens, and they get the benefit of a full and fair hearing with all the constitutional protections that every other Michigan citizen gets. And if the judge determines that they have bad credibility and they're a liar, it'll probably impact their outcome.
I think there was even an unpublished case involving a PPO that was issued and then rescinded because it turned out the allegation wasn't true or something like that.
Right. And
so some of this depends on timing as well.
Well, and in the cases that were cited, in the Diode case and some of the other cases that were cited, I think the distinction, and the really critical distinction in those cases, is the domestic violence was alleged after the agreement to arbitrate was made. In one of those cases, after the arbitration was held, the arbitration decision was received. And it appeared that one of the parties was unhappy with the arbitration decision and was now using the allegation of domestic violence as a way to set aside an arbitration decision with which they were unhappy. And that, in a way, has somewhat of a parallel to the instant case that we have here, which is, in this case, appellant chose the trial court to file the litigation. And this case was being litigated for 6 months. The trial court in this matter had held hearings and had decisions on parenting time matters, had made decisions on discovery matters, had made decisions on financial matters, had made decisions, and a trial date was set. And it wasn't until 6 months into this case, not 6 days, not 6 weeks, but 6 months into this case, that for the first time, Appellee, after receiving all these substantive decisions, Appellee filed a motion and said, I want arbitration. And as you can see on page 26 of our brief, the trial court judge said, I'm troubled by the fact that 6 months into this case, after these substantive decisions, you are now asking for arbitration. This feels like forum shopping. And that, to me, is more on track with what happened in that Diode case. That all of a sudden, appellant had chosen the trial court, had been litigating in the trial court until all of a sudden, when we're getting all these decisions, we ask for arbitration. And that is more on track. Mr. Lowry, in his very first response of pleading, in his answer to a motion for an ex parte order, raised domestic violence. And he has been steadfast and clear about those allegations, and he has been steadfast and clear about his desire not to waive the domestic violence exclusion. And I believe that appellant's analysis of MCL 600.5072 is absolutely incorrect. I think you read this statute and you go through section 1, 2, 3, and 4, and it goes through what the trial court's obligation is when parties come and they say, we are asking the trial court and saying that we would like to remove our family law case from the circuit court, state court, protections, and we want to take our family out of the state court constitutional realm that every case is heard in into a private arbitration, then the trial court judge at that point has a responsibility to take a look at it and say, why? What's going on here? Do you know what you're doing? Is this safe? Is there coercive control going on? Is there domestic violence going on? Are you making a voluntary and knowing decision? It is my obligation as a representative of the trial court to make sure that no one is being coerced, that you know what you're doing. And the statute since 2001 has been very clear about the responsibilities of the attorneys and the judge involved. And the attorneys cannot make that decision on their own. The parties cannot make that decision on their own. And the judge cannot send anyone to arbitration. The parties cannot decide to go to arbitration. This is an entire statutory scheme that works together harmoniously and must be entirely looked at together.
I think we've got it. Unless there's something else, we'll hear any rebuttal and we'll get to work.
Very good. Thank you.
Okay, thank you. Mr. Killis?
Thank you, Your Honor. I'll try to keep it to 3 points. So first, a statement was made that it is uncontested that there are allegations of domestic violence here. I just want to make very clear that the big word there is the word allegations.
Yeah, there's been no conviction of anything.
Absolutely. And one thing that's really important under this.
Is this case been referred to the prosecutor's office?
Not that I'm aware of. And I think that's a really important part of this, because when we talk about this get out of arbitration free card that I mentioned in my brief and you quoted, Your Honor, these allegations never have to be tested. So as Ms. Sendelbach said, what's the harm if allegations are made for the pure reason of getting out of arbitration? Apparently there is none.
Did the trial court judge question the domestic violence allegations?
I don't believe so. The transcript is in the appendix.
I'll have to take a look at it.
At this point, it's been, a few months since I've gone back over that particular part of the record, but I don't believe the trial court ever went into that.
What I understand their point of harm is that, if you've made these allegations before the court and now the court says, okay, well, I understand, this matters now before me. And then you go forward and that you've made allegations, say in a cynical way.
Sure.
To avoid arbitration, then presumably you've done that in front of the decision maker charged with adjudicating your credibility and your ultimate success on your dispute. So it seems like there's perhaps some incentive baked in there, not to be too cynical in terms of your use of these allegations relative to your arbitration.
There's certainly some incentive, Your Honor. I would obviously never recommend anybody be anything but forthright and truthful in front of a court. I certainly do my best. But I don't think that those allegations would ever necessarily even have to be tested. Like, it would never come up again. This case is about how do we divvy up this property? How do we handle custody? How do we handle parenting time? It's not a domestic violence case. Even if there were going to be a domestic violence case, that would be handled through a referral to the prosecutor's office or action for a PPO. That's going to be handled someplace else. So in this case, these allegations can be made, and if made cynically, just left to sit there, never touched again, never raised again. It truly becomes a get out of arbitration free card. And I think it's very unlikely that that is what the legislature intended here.
You know, we have to look at what the legislature intended, no doubt. And it seems to me that, you know, the statute is probably geared towards domestic violence relating to the divorces that's taking place. I'm gonna have to take a look at the rule of absurdity, but that may be applicable here. An arbitration agreement that was entered into 12 years beforehand. I mean, where's the risk to the parties? I don't see it. But anyway, that's just me thinking out loud.
Well, I do, but I sympathize with that, Your Honor, because as I was thinking through this, that was something I kept coming back to as well, which is, well, if the legislature was concerned about this, what would they have done? How would the statute look differently? And I think it would have been very easy for them to move a domestic violence allegations test up under 5072 sub 1. We're not going to order a party to participate in arbitration if that party alleges that they are the victim of domestic violence. That would have been an easy way for them to handle that would have addressed exactly that potential concern if that was something the legislature was concerned about. They structured the statute very differently, and that has to be meaningful here. The second point is, counsel used the phrase, the parties can stipulate to ask the court to refer the case to arbitration. That is absolutely not what section 5071 says. And I don't mean that she was purporting to quote the statute, but that's not any even paraphrasing of it. 5071 just says you stipulate, and that's it. Just like Court Rule MCR 7.212 says you stipulate to the extension, and that's it. It is not a joint motion to allow the parties to arbitrate. And in fact, one way we know this, it is perfectly acceptable for parties to go through the whole arbitration process without ever filing a complaint.
But 5071 starts with parties to an action.
Yes.
So it seems like we're in a space where there's an action.
Yeah, 5071 speaks up once the parties are in an action, right? No question about that. But parties could, if they chose, stipulate to or agree to an arbitrator. They're going to get divorced. They agree to an arbitrator. They know a family law attorney they trust to handle these matters for them. They go through the whole arbitration process. They get an award, and then they file their complaint and submit the award to turn it into a judgment of divorce. That is perfectly acceptable. Doesn't happen very often, but it's absolutely acceptable with this statute. You're right. 5071 kicks in once there is an action, and that's why they need a stipulation to tell the court we're moving to arbitration. But the stipulation is automatic. It's not a joint motion. It's not mother may I. It's the legislature gave us the right to do this thing.
Just going back to the arbitration agreement itself. Yeah, both parties were represented by counsel, correct?
Excellent counsel. Yes.
Yeah, I know. One out of New York and the other out of Grand Rapids, I think.
Yes.
Okay. Just confirming.
Oh, yeah. Yep. Sorry, Your Honor. And then finally, I want to address this issue of waiver and forum shopping. Alyssa filed this action and sought the circuit court's help on one issue before asking to arbitrate. She wanted immediate protections for her children because she felt they were in danger. I don't want to get into those details. They're in the record. They were under seal. We'll leave them there. But that's what she was asking the circuit court to do. At the same time, her counsel was constantly sending messages to Nate's counsel saying, let's pick an arbitrator. The arbitration agreement says we have to arbitrate, or we have to choose arbitrators, or if we can't agree, you pick one, I pick one, and they together choose an arbitrator. There's a process for this. But let's get this process started. In fact, in her complaint, when she started this action, she said this is subject to an agreement to arbitrate. Right? Nate never disputed that. And in fact, when I think it was the third or the fourth email, finally Nate's lawyers responded to Alyssa's lawyers, Their only objection to arbitration was the fact that she filed an action in the first place, said nothing about domestic violence in there. But the reason there was a 6 months delay was because Nate's lawyers were silent. So they're manufacturing a delay here when there was no intentional delay. There was an emergency situation that came up, and from the initial pleading, an indication that Alyssa wanted to arbitrate this case and that there was an agreement to arbitrate. So there's no forum shopping here. This was always the intention.
Counsel, sorry to interrupt, but your time's up.
That's fine. My point was up. Thank you, Your Honor.
Thank you very much. That case will be submitted. Thank you very much for your arguments. Moving on to item number 26, docket number 378102, Ryan Smith versus Amanda Sadler. We do have oral argument endorsed for the appellant. Good afternoon.
Good afternoon, Your Honors. We're here today on behalf of the appellant. I'm here on behalf of the appellant and we're requesting the court to look at several issues as noted in our appellant's brief. The first issue of the multitude of issues in this case is the issue of the trial court taking this issue up on de novo review. And I'd like to draw the court's attention to the procedural history of this case. In this case, the appellant had sole legal custody and sole physical custody of his daughters. In this case, issued from the original trial court, Judge Maurer issued an ex parte order suspending appellee's parenting time back on August 15th of 2022. And at that point in time, the order was referred to the FOC for an issue after objection on the issues of parenting time. That matter was scheduled before the referee in Eaton County on March 24th of 2023. As the record is clear, there was one referee hearing held. That referee hearing was in front of referee Schlossberg. And at that point in time, there was an open-ended issue of following up with compliance with appellee's mental health, Dr. Smith, with the understanding, at least ostensibly by looking at the record, that there'd be another referee hearing held. At that point in time, the order was still the ex parte order. So in fact, at that point in time, appellee had no parenting time with the minor children. 2 years passed. 2 years passed with no contact by appellee with the children. And then at some point in time, it appears that the court noticed there was no final order.
Safe to say things kind of fell between the cracks.
It's very safe to say, Your Honor, that this
That was my impression, is like
100%. It looks, if I'm in Eaton County twice a week, this case probably just didn't get calendared. So the court audited the file. We need to have a hearing. So in March of 2025, trial court takes it up for de novo review. Appellee requested it. Essentially, the court's order was, if no one lets us know they want to have a hearing, the order from August or the original ex parte will stand. Appellee lets the court know she wants a hearing. Register of Actions indicates we go in for a series of parenting time reviews. Okay, so we go in and the record is clear that Dr. Hobbs is brought in, who is very well known and well respected in the Tri-County area for reunification counseling. And there's a series of supervised visits. There's a series of orders, and ultimately we end up with a September order after de novo review, modifying both legal custody and physical custody based on a burden of proof of clear and convincing evidence. Now, it is the appellant's position that there is a plethora of issues that are brought up in our brief. So under the so we have in fact have a bifurcated issue in this case. You had two fact finders. You had original referee hearing, and throughout this procedurally, there was an issue of mental health compliance. And when we went to the parenting time reviews, there was testimony by appellant Dr. Hobbs and spouse of appellant. That's it. That's all we had. And the referee had the original FOC of completed it with the original fact finder, there would have been a 21-day recommendation period. So, and I'm going to kind of hula hoop through it because I think procedurally this case is very linear, and that's just the best way for me to describe it. The referee would have procedurally issued a 21-day. No one objects to it. It becomes the order of the court. That never happened. The first thing that didn't happen, Dr. Hill was never followed up with. And as the court, without going into the, privacy issues of the mental health challenges in this case, that was never done. So there's no 21-day. The only reason it was brought up on de novo review was because it fell through the crack. The parties were never given the benefit of what the original fact finder would have found under MCR 3.21. The additional thing that we argue is that the appellant, his due process rights were violated. And I'll get more of that into the abuse of discretion argument when the trial judge modified legal custody. So if we look procedurally and linearly back into the register of actions, there's never been a legal custody motion filed in this case. This was never before the court. And under MCR 2.119E, which,
I'm sorry, counsel. My understanding is that back in May of 2022, moved to modify custody and parenting time.
They did, Your Honor, but that was a physical custody situation. If we go back to the actual pleadings, it was not pled. So when we go back to legal custody, the issues that were isolated before the referee were issues of parenting time and physical custody. And so it was a parenting time issue. Legal custody was not.
The referee's hearing in August.
Correct.
Yes, but I think by the time this case got to the de novo review, the defendant's motion to modify custody and parenting time was technically still pending. There was a recommendation from front of the court that he denied, but and defendant objected to that recommendation.
He did.
And then things kind of fell apart from there.
It was still there, but it was not a legal custody. It would have been a custody issue, but the legal custody issue was not specifically pled.
All right, so you're saying that it was only a physical custody
Yeah,
motion,
so the issues
not a
in this
legal
case really surrounded by the original issue of physical custody and parenting time. And so the argument here is that, in giving the appellant fair and proper notice to properly defend a claim, if it in fact was an issue, that it should have been properly pled first and foremost under MCR 2.119E. Getting into the whole issue of the de novo review and the scope of the parenting time review hearings and so forth, I'll get there. But it's our position that that was not followed and that is an issue of due process where he would have had an opportunity under a normal motion practice, had it have been properly pled, to defend that claim. In fact, all of us, including myself, had no idea. And in fact, if we look at the judge, if we want to even go to the micro, the judge never mentioned it any time during the parenting time reviews. The only thing she said that we are coming back for an evidentiary hearing. The judge on every single register of actions notes parenting time review. It also notes it in the order. It is very intentional.
Which order? Sorry, which order?
So
the order that says it's been too long,
Well, yeah, so we have the June and then July. So the parenting time review hearings had follow-up orders. So if we look at the orders provided by my office in our brief, they specifically are parenting time orders that correspond to the parenting time review hearings. So each hearing essentially expanded the appellee's parenting time by some measure, supervised to some measure of that. So I think that was very intentional by the judge, and the transcript will not reveal at any point in time, does she mention it didn't even mention legal custody. I think appellee may have been asked, what would you like, in a perfect world? And she had mentioned, yes, I would like joint legal custody. But that again does not amount to putting appellate on notice properly to defend that claim. The next issue we have in this case really is the findings of fact by the trial court. And I think I'd like to really expound upon that. As the Court of Appeals is aware, it's whether or not they go against the great weight of the evidence. And in fact, when I read this opinion, I essentially had to read it 5 times. Because when I looked at each factor, it almost as if the trial court said, well, because because mental health treatment was clear, because there was compliance, each factor is equal. But when we look to the facts, that's not justified by the facts in the record. If the court looks back to the record in March 2024, and we go to the de novo opinion, the appellee discontinued her treatment with the therapist, Esther Dale, and because she wasn't paying her reunification bill and she refused to sign the parenting time plan. When we go to top of page 5 of the de novo review, the appellee indicates at that point in time, and I believe this was after the June 11th, 2025 hearing, that she was treating with a psychiatrist and a psychologist. And under direct examination was specifically requested to speak very specifics on who she was treating with. Because if the court's aware and we look back at this, there was significant history of mental health concern. And she invoked privilege, which is her right. But the judge, as noted in her opinion, after the July 30th, 2025 opinion, says that she advises the appellee that her noncompliance with treatment or showing a medication that doesn't have to waive privilege, but that she can make a negative inference based on the fact that she didn't produce any sort of corroboration of her self-reporting. The judge's opinion then goes on to use her self-reporting as a basis for her burden of proof. And that was clear throughout. She then, at several points in her opinion, points to Dr. Hobbs, because none of the letters cited by the judge in this were ever admitted into evidence. They were just reviewed on the record. Dr. Hobbs, who's a psychologist, who's been a psychologist for years, was directed under oath in 9/1 of 2025, and this is in the de novo review order, said that she was not independently able to verify compliance with mental health treatment. So the trial court then goes on to factor, we have her weighing factor C, we have her weighing under, factor B, essentially saying that because her mental health everything's compliant, she's able to do these things. But there's case law that indicates that there's more than that that's needed. So under factor C, I brought up the Prozoga v. Jackson case. The finding in that case found under this factor that under the great weight of the evidence, that was a case that involved like child support and arrearages, where they found that someone might have had the disposition, or the capacity, but not the disposition. So they had the earning capacity to support a child, but not the disposition. Now, factually, it's dissimilar, but in this case, there's no testimony to show, like if you look at the record, none was elicited from the appellee showing that she had the capacity nor she might have had maybe the disposition, or you infer it based on her discussion, but there's nothing. But yet that factor is equal. Yet we look at what happened with the appellant, and he's the sole provider of the children, the sole provider of everything, but yet that factor is equal. And her rationale is her mental health treatment is clear. So we're 50-50, what's equal. But her opinion is not congruent to how she conducted herself during the hearings. And a multitude of times advising, if you invoke privilege, I can make a negative inference about what your mental health compliance is, yet she does the opposite.
I know you're keeping track of your own time. You have 15 minutes.
I am. I'm at 12 minutes and 44 seconds.
I was getting close. I'm looking at the clock too.
I also want to trust, I'm going to go through factor L. Interestingly enough, the judge talks about the fact that she's not going to hold the last 2 years against her for not seeing the children. This is an interesting, I've never seen this in an opinion in my entire life. I don't know how this was introduced in here, essentially saying, well, you haven't seen your children in the last 2 years. We're not going to hold that against you. And that's just a very odd situation. And, our position is that it was an improper and against the great weight of the evidence issue, and should not have been in part of this opinion. Ultimately, though, under Fletcher v. Fletcher, We do believe ultimately, though, that the trial court abused its discretion when it issued legal and physical custody modifications, especially as it relates to that, because not only were the findings under the factors against the great weight of the evidence, excuse me, but that the result was so palpably and grossly violative of logic. There was simply, I mean, honestly, we have no idea how she got to these conclusions. And we believe that when the court examines the register of actions, the transcript, and all the supportive findings, that the court will remand this case. That's our request. I'll take any questions.
I have just one quick one.
Yes, John.
I'm looking at the May 2022 motion by appellee, and it appears, you know, the first item, for instance, of the relief requested is to award the defendant joint legal and physical custody of the minor children. So I guess that seems to me to go back to we were speaking about due process. That seems to comprise a request for legal custody. Is there a different motion I should be looking at?
No, so that one was the original, and then it was objected to, and then the ex parte was entered. So this is a procedural posture where the ex parte sort of intercepted this procedural case, and then it was referred, the ex parte was what was referred for the referee hearing.
But this other motion was still pending.
That motion at that point in time,
I guess I'm not sure. It was plaintiff's ex parte, right? So
it was the plaintiff's ex parte. So the way that it would have worked in Eaton County is that if that would have been consolidated into the referee hearing, it was not consolidated. So the scope of the hearing for the referee that was in March of 2023 did not encompass legal custody. So when the judge when the trial court took this up on de novo, it was based on the procedural from at least by my calculation, from the ex parte forward.
You're saying that the defendant's motion was not properly before the circuit court at the de novo hearing?
No, because when she referenced the de novo review, it was the ex parte, the 8/20/2022 was the cutoff. That was going to be the order of the court. So anything retroactive to that was not, like, that's what we were having. And so that order, that motion precedes that order. When we went before.
No hearing was ever held on it, is what you're saying?
No. And in fact, when she references the de novo, it is specific, very specific, that the 8/20/22 order would govern. So when she made this, it was very purposeful. And so when we went to this hearing, the understanding was if appellee doesn't raise any issue, then that governs. And so it'd be a suspension. So anything before that, you know, that was a line drawn in the sand by the trial court. So it was our understanding that the issues of the referee hearing, which were parenting time, very specifically, because she articulates it in her opinion, or what were being before her, that hearing. She went through very, very specific parenting time factors, call them parenting time reviews, and I'm out of time. Thank you for the court's time today.
Thank you very much. We appreciate this. That case will be submitted, and
thank you, Your Honors.
Have a good afternoon. Next case on our docket is item number 27, docket number 377177, In re Cook Cheney minors. We don't have oral argument endorsed for the appellant. We do have oral argument endorsed for the appellee. Good afternoon.
Good afternoon, Your Honors. Good afternoon, Your Honors. May it please the court. Kara Thompson on behalf of petitioner appellee, the Department of Health and Human Services. We're here today to answer the question of whether the trial court clearly erred in finding whether or not the department made reasonable efforts for reunification between the respondent appellant, David Cook, and his son. The answer is no. While the department has an obligation to expend reasonable efforts to provide services to secure reunification, there's a commensurate responsibility on the part of the parent to benefit from the services provided pursuant to In re Fray 297 Mich. App 242/2012. The record established that the department made consistent and reasonable efforts for reunification, including the following: spending 6 months attempting to locate Mr. Cook while he was AWOL, creating a parent agency treatment plan, offering Mr. Cook AA services, coordinating with the local jail and MDOC after Mr. Cook's arrest so that he could be present at all of his hearings, facilitating phone calls and video visits so that Mr. Cook could have parenting time with his son, and recommending parenting and therapy services through MDOC. Michigan law requires reasonable efforts, not extraordinary or impossible ones, and those efforts must be viewed in light of the circumstances of each specific case. Mr. Cook suggests that much more could have been done to secure reunification due to his incarceration. However, the law does not impose a higher burden on the department simply because one is incarcerated. The department is required to provide reasonable efforts, not overcome the realities of incarceration. And those realities are significant here. Respondent is serving a lengthy incarceration sentence for violent felonies. His earliest release date, as stated in the brief, is no longer September of 2026, but rather has been pushed back to June of 2028. And his maximum release date extends far beyond that, all the way to 2044. The department cannot manufacture reunification where a parent will remain unavailable to a child for years. Mr. Cook's extended minimum release date eliminates any reasonable prospect of reunification within a time frame that would be meaningful to the minor child. Additionally, a respondent must establish that he or she would have fared better if the petitioner had offered other services pursuant to In Re Fried 266, Mish App 535, 2005. Mr. Cook participated in voluntary services and additional services offered by the jail, but he still did not benefit from these services. Mr. Cook evaded the department for 6 months, and he even admits that in his own brief. He only became engaged in this case after he was incarcerated. This then limited the opportunities for engagement between Mr. Cook and his son, and the length of his incarceration will continue to limit those opportunities. Now, before Mr. Cook emerged incarcerated, he had no involvement in the minor child's life. He had effectively abandoned him. He provided no support, financial or otherwise, during his incarceration and after his incarceration.
Counsel, are the appellants challenging anything about the statutory grounds or best interests? As I read their brief, it seemed to be focused on the extent of efforts.
We are not challenging, he is not challenging any of the statutory grounds, only reasonable efforts to reunification.
He at the end of his brief mentioned a few things that he felt maybe could have been done. You know, you could have waited longer. Maybe a long-term guardianship with a foster care parents. Maybe something with the father of the other child. What do you have any response to that in particular in terms of those options that he presented in the brief?
Yes, Your Honor. So at the time of the termination trial, this minor child had been in care for a little under 2 years. That's a long time for the child to be in the system. And at this time, he was around 10 years old. He needed permanency. And at this point, Mr. Cook was not able to provide that permanency, nor when looking at the bigger picture long-term based on his possible release dates and any services he was currently participating in that he needed to show benefit from. The time was just simply not there. So we had reached a point in this child's life in which he needed this stability and this permanency to move on with his life. And that's something that the department highly valued. And if we were to wait for Mr. Cook to be released out of his earliest release date, that's just longer time that the child would have to be in the system, and that's just time that he didn't have. He needed stability and he needed permanency.
I guess what would be added, or I guess what would be lost with the guardianship in terms of permanency for the child for the time being, at least for a bit.
So the child had found himself in a foster placement at which he had developed a strong bond with. They were providing him everything that he needed. He had even asked if he was able to stay with his foster parents forever. The child found himself in a position in which he had the life that every child deserves at that point. and the stability and the permanency that he very much needed was not going to be provided at that time, nor anytime soon with Mr. Cook.
Thank you, counsel.
So Mr. Cook relies heavily on In re Mason 486 Mich. App 142, 2010. However, that does not control in this situation. In Mason, the parent was actively engaged with his child. He requested services multiple times from the department. He had family members willing to take custody of a placement of the minor child, and he was excluded from the proceedings. The opposite is true in this case. Mr. Cook disappeared for months. He avoided the department until he was incarcerated. He provided no support to the minor child. He failed to identify any relatives willing to take placement of the minor child, and he was included in every proceedings once the department was able to locate him. Mason protects parents that are trying. It does not protect parents that fail to engage and remain unavailable for years. More importantly, the termination was in the best interests of. He was in a stable, loving foster placement with a strong bond with his caregivers. He expressed a clear desire to remain where he was and to be adopted, and he even asked to stay with his foster parents forever. Whereas Mr. Cook is to remain incarcerated until at least June 2028. He has no ability to parent during his incarceration other than through phone calls or video calls. He has no placement alternatives for the minor child, and he has no realistic plan for reunification. And that timeline matters. The minor child should not be asked to wait. Not 2 years, not 4 years, certainly not on the mere hope that Mr. Cook will find eventual stability. A child's need for permanence and stability cannot be postponed indefinitely. Your Honors, there is no clear error, there's no plain error, there's no basis for reversal today. Just because Mr. Cook did not benefit from the services that were provided to him does not mean he gets to make the argument that the services were not reasonable and the efforts were not reasonable. The department did what the law requires of them. Mr. Cook did not. The minor child's found stability, safety, and permanence, something he did not have before. The trial court recognized that, and this court should affirm. Thank you. That's all I have. I will take any questions.
Nothing more for me.
Thank you very much.
Thank you, counsel.
Appreciate you being here.
Thank you, Your Honors.
That case will be submitted. Have a great afternoon.
Thank you.
The final case on our docket is item number 28, docket number 377570, Tricia Winkler versus John Edward Winkler. Both parties have requested remote appearance. They're not endorsed for argument, but their appearance will be limited to answering any questions. So I think the best thing for us to do is bring them up if they're here, have them on the screen, and then we can see if there are any questions for either of them.
Hi, judges. This is Stephanie in the clerk's office. Mr. Diedrich is in there, but Ms. Hamblin is not in the attendees.
Okay, well, thank you. We'll see Mr. Diedrich then. Good afternoon, Mr. Diedrich. How are you?
Your sound is off.
Whoop, we cannot hear you.
I apologize, Your Honor. Todd Diedrich appearing on behalf of Mr. Winkler.
That's quite all right. So we're just here to see if anyone on the panel has any questions for you. Judges?
I have none.
No, none from me.
Okay, and I don't have any questions either. So we really appreciate you being here, and we will decide the matter on the briefs.
Thank you very much, Your Honors.
Thank you. Have a great afternoon.
Thanks for waiting for us.
All right, that case will be submitted, and that concludes case call for this afternoon. Thanks very much.